to start?
Right here? Yep.
Good morning. This is a public hearing of the New York State Assembly Standing Committee on Environmental Conservation on the subject of the revised draft supplemental generic environmental impact statement prepared by the New York State Department of Environmental Conservation. We do have a busy day. A lot of people have expressed an interest in this hearing and to testify at this hearing. I will start by stating for the record that the invitation was a general, to testify was a general invitation open to everybody. We did specifically make a point of inviting industry representatives to appear, but with the exception of the New York State Petroleum Council, they have declined to do so. For everyone else who is here to testify, I'm going to start by thanking you in advance for your patience. We have 73 people scheduled to testify at this hearing. You can do the math. So we are asking everyone, and the notice that went out, there was, as is standard for an assembly hearing, a 10-minute oral presentation. We are asking everyone to stick by the 10 minutes. There's a clock on the table. We'll stop you after 10 minutes. So for those of you who are testifying later, please adjust whatever presentation you may have. The 10 minutes, of course, does not include time for questions and answers, which we frequently find to be a productive part of this process. So everyone, 10 minutes for oral presentations, followed by questions and answers if there are any members of the panel who have questions and answers. It is always appropriate, if you wish to summarize your testimony rather than read it to us. Written testimony becomes a part of the official record. If you wish to summarize it, which again gives us a little more time for questions and answers, that would be an appropriate thing to do. If there's anyone here today not scheduled to testify, but who would like to be on the record, we will accept for a week from today any written testimony. You can submit it by mail, by email. It will become a part of the official record. Having said that, I'd like to note that present for the start of this hearing are my colleagues, Assemblywoman Barbara Lifton and Assemblyman Steve Engelbright. And with that, I think we are prepared to start. And our first witness is Joe Martens, Commissioner of the New York State Department of Environmental Conservation. Commissioner, welcome. Thank you for being here. I will also ask everyone who testifies today for the official record to please state your name and title as you start. Thank you.
Thank you, Chairman Sweeney and members of the Assembly Environmental Conservation Committee. I'm Joe Martens, the Commissioner of the Department of Environmental Conservation. I want to thank you for the opportunity to testify about DEC's revised draft supplemental generic environmental impact statement, always a mouthful, on high-volume hydraulic fracturing. I want to introduce members of my staff that are here with me today, and if you'll indulge us, this is the executive team at DEC. Mark Gerstmann is my executive deputy. Gene Leff is deputy commissioner, and Steve Russo is deputy commissioner and general counsel. And this is really the team that helped finalize that document that you see on the table next to you, which is the supplemental generic environmental impact statement. While gas drilling has proceeded at a sprint pace in Pennsylvania and other states, New York and DEC have proceeded cautiously and deliberately in developing a responsible approach to gas drilling. I've said time and again that DEC will not issue permits for this activity until I'm satisfied that it can be done safely and responsibly, and I continue to make that pledge. For more than 3 years, DEC has been intensively studying the potential environmental impacts of the use of high-volume hydraulic fracturing to extract natural gas from shale formations in New York State. We've held 10 hearings to date on the scoping of the study and on the 2009 draft of the SGEIS, and received more than 13,000 comments, and consulted with numerous states on high-volume hydraulic fracturing issues that they have confronted. We have used the time since the 2009 SDIS was published to learn from the experiences of other states and identify measures that will protect our drinking water, our streams, our air, and our land. In July, DEC released a nearly complete version of the revised draft SGEIS to allow the public the opportunity to begin reviewing the revisions made since 2009 in response to new information, comments received from stakeholders and the public, and evolving scientific and technological developments. We added the community impacts portion of the document in early September. At that time, DEC formally issued the 2011 revised draft SGEIS for public comment. As you know, the department was urged by many stakeholders to adopt regulations, and on September 28th, DEC issued draft regulations to codify and reinforce most of the mitigation measures recommended by the draft supplemental SGEIS. It's important to remember that the 2011 draft SGEIS is not the beginning of the process. We've been at this for over 3 years. Executive Order 41 directed DEC to update the 2009 draft and to ask the public to comment on the changes made in the intervening time. The latest draft builds on and greatly improves the analysis contained in the 2009 draft. Most important, it adds significant protections recommended by scientists, engineers, and significantly our colleagues at the Department of Health to ensure that gas drilling is undertaken in a manner that protects public health and the environment. We achieved that goal by ensuring that the 2011 draft SGEIS was both conservative in its assumptions and exhaustive in its analysis of potential significant adverse impacts. For example, the maximum drilling scenario was used to identify potential significant adverse impacts and to develop mitigation measures to address those impacts. Conversely, when presenting potential economic benefits of gas drilling, we used low to average development scenarios. The result is that DEC has proposed a regulatory framework that is the most protective in the nation. The 2011 SGIS provides additional measures to protect drinking water, includes a series of setbacks and prohibitions on drilling in sensitive areas. For example, the SGIS proposes prohibiting drilling in the New York City and Syracuse watersheds because activities associated with drilling in those watersheds could increase sediment loads and risk the loss of EPA's filtration avoidance determinations under the Federal Safe Drinking Water Act. The loss of the FADs and an EPA order that these water supplies be filtered would obviously have enormous fiscal consequences. For New York City, the cost could be more than $9 billion. That does not mean, as some have argued, that the SGEIS treats other watersheds as second class. The suite of protections we have proposed would protect all water supplies, public and private. The draft SGIS proposes rigorous setbacks from all water supplies. It recommends prohibition on surface drilling activities within 2,000 feet from all other public drinking water supplies, above primary aquifers or within 500 feet of them, within 500 feet of private wells unless waived by the landowner, or within 100-year floodplains. A site-specific environmental review would be required if any portion of the well bore is less than 1,000 feet below a known freshwater supply or less than 2,000 feet below the ground surface. It'd also be required if the well pad is atop or within 500 feet of a principal aquifer, or the well pad is within 150 feet of a perennial or intermittent stream, lake, or pond. Well testing would also be required prior to commencing drilling activities for all private drinking water wells located within 1,000 feet of a proposed well pad, or within 2,000 feet if there are no wells within the smaller radius. We've learned from our study of incidents that have occurred in other states that contamination problems generally relate to spills or accidents at the surface, usually at the well pad, or poor well construction. So in addition to the proposed setbacks, the SGEIS includes provisions for primary and secondary containment, elimination of surface impoundments, aggressive stormwater control plans, extensive monitoring, and other measures designed to prevent or mitigate against the risk of surface spills at a drilling site. We also require strict specifications for well construction. Gas migration into water wells is a significant issue that has received national attention. Fortunately, DEC has long recognized the need for proper cementing and well casing and has an exceptional track record. DEC staff review cementing and well casing plans for every proposed well, and that would not change under the revised SGIS. Further, DEC would require a third string of casing, known as intermediate casing, to help ensure that there is no communication between shallow gas and aquifers during the drilling process. DEC also recognizes the need for the public to know the components of fracturing fluids, and that many in the public are concerned that such additives could be harmful. Since 2008, DEC has required gas companies to disclose all chemical additives, product names, and volumes used in hydraulic fracturing fluid. This information has and will continue to be shared with the public and the health department. As required by law, there will be limited exceptions to full disclosure to protect trade secrets. The draft SGIS would also require drillers to explore greener alternatives to fracturing fluids that pose less environmental risk. The draft SGIS also fully examines the potential impacts from waste streams from high-volume hydraulic fracturings. Applicants will have to provide DEC with their disposal plans before any drilling permit is issued. We've learned that less water than was previously anticipated returns to the surface after fracturing is completed, and industry is recycling flowback water to further reduce the amount of wastewater that has to be disposed of. Nevertheless, significant quantities of wastewater will be generated, and DEC will not issue any permit until it's satisfied that that wastewater will be sent to a properly permitted facility, either here in New York or in other states. In addition to the areas that I mentioned earlier that will be off limits to drilling, the SGIS recommends limits on drilling in environmentally sensitive locations such as mature forests and grasslands to prevent habitat fragmentation. I don't know of any other state that has similar requirements. The SGIS and proposed regulations also prohibit surface drilling associated with high-volume hydraulic fracturing on sensitive state-owned lands, including reforestation areas, wildlife management areas, and state parks. DEC has concluded that drilling on state lands is simply not compatible with the purposes for which those lands were acquired, which primarily is public use and enjoyment. Finally, I've seen firsthand that high-volume hydraulic fracturing can result in substantial increases in truck traffic and have significant noise and visual impacts. That's why I directed staff, with the help of a consultant, to analyze those potential impacts and propose additional mitigation measures. The expanded draft SGIS released in early September thoroughly explores these impacts and proposes mitigation measures, such as requiring a detailed transportation plan that would identify proposed truck routes and evaluate road conditions along those routes. Those plans would accompany permit applications and be reviewed by DEC and the Department of Environmental Conservation. We'd also consult with local governments and, where appropriate, place limits on the number of wells or well pads that can be constructed in a specific area at the same time to minimize truck traffic, noise, and visual impacts. The last installment of the SGIS explores the potential economic impacts of high-volume hydraulic fracturing as well. It documents the anticipated significant increase in jobs, both direct and indirect, and state and local tax revenue streams that could be realized. The projections conclude that between 13,000 and 50,000 plus new jobs could result from drilling, depending on the level of activity, and result in economic impacts between $620 million and in excess of $2 billion. As you know, DEC will receive comments on the draft SGIS through December 12th and will hold 4 hearings, 1 in New York City and 3 across the southern tier. DEC also recently proposed draft regulations to codify most of the conditions and mitigation measures recommended in the SGIS. As the regulations are based on the requirements and conditions of the draft SGIS, it makes sense to conduct concurrent hearings and comment periods on the SGIS and draft regulations. When revisions are made to the SGIS in response to public comments, revisions will also be made to the regulations. Combining the comment period for the draft SGIS and the regulations is not an attempt, as some have claimed, to fast-track or short-circuit our review process. Since the two go hand in hand, it simply is an efficient, rational way to go. I should mention in closing that I've been meeting with my advisory panel on high-volume hydraulic fracturing, which I've asked to develop recommendations on state resources needed to properly oversee, monitor, and enforce conditions for hydraulic fracturing in New York. The panel will also be looking at local impacts and resource needs. I've asked the panel to provide me with interim recommendations in early November to inform the executive budget requests put forth by the involved agencies, with a goal of completing final recommendations in early February 2012. In sum, I believe the SGIS is comprehensive, covering every aspect of gas drilling activity from construction to production to reclamation and closure. I know that I've only scratched the surface of the analysis that's contained in the report on the table here, but I'm happy, along with my staff, to answer any questions that you may have. I really appreciate the committee's involvement in this issue, and I know to a person you've all been very actively engaged, and I appreciate that. And I look forward to both working with you on this issue and to the public comment period that lies ahead. We're all available for questions. Thank you.
Thank you. And if I could ask, of course, the questions will be for whoever wishes to respond. If you could just pull the microphones a little bit closer, it might be easier for all of us to hear. Thank you. And I'll note that we've been joined by Assembly members Brian Kavanaugh, Dan O'Donnell, Donald Lapardo, Ellen Jaffe. So let's start. If you could tell us, please, what you think are the most significant changes to this document from the original document.
As I outlined, Assemblyman, the changes, I think, are fairly significant. We increased a whole variety of setbacks from water supply sources. We would prohibit drilling within the New York City, excuse me, and Syracuse watersheds. We would prohibit drilling on and within 500 feet of primary aquifers. We would also, there is a host of areas that would not be covered by the SGIS, but would require site-specific environmental review if drilling is proposed in those areas, significantly within 500 feet of a principal aquifer. So if a driller wants to drill within 500 feet of a principal aquifer, they would have to do a site-specific evaluation, which DEC would then review. Similarly, there are other areas, setbacks from streams, water supplies. We enhanced all of the wastewater treatment recommendations in the SGIS, and control and containment at the site have all been significantly enhanced. As I mentioned in my testimony, containment areas and then secondary containment areas will be required and will be covered by a stormwater general permit that is being specifically designed for this industrial activity. That's a list of few. I'm sure there's others. Obviously, we took a much more thorough and in-depth look at community impacts. That was the additions to the SGIS that we included in the September draft, which came out on September 8th, I believe. I'm sorry, I'm losing my voice here.
Okay, that's several of the protective measures in the document are accompanied by waivers or sunsets. For example, if it's not advisable to have well pads in principal aquifers, why should this decision be revisited in 2 years? And if additional casing is a good protective measure, why wouldn't it apply in all drilling situations and not be subject to waiver provisions?
That's a good question. I don't think, frankly, we needed to put in those provisions in the SGIS. I think experience is going to inform us as we go through this process. We could come back in 2 or 3 years after, we could come back in 6 months and decide that we change a specific requirement. But we are putting in regulations the things that we think are absolute minimums. But for example, review of drilling near principal aquifers, we're going to see what our experience tells us, and we may have to come back and adjust it. It may be more stringent in the future or less, depending on our experience in the field.
Well, why would you have a waiver on the protective casing in some cases?
Well, the intermediate casing, again, will be a requirement that an applicant could come into and specifically ask for a waiver for based on the actual subsurface conditions at a particular well pad site. is becoming more and more common in the industry for intermediate casing to be used, and I would say that it would be rare if it happened in New York, but there may be very small number of exceptions, again, based on very specific subsurface conditions that would, might compel the agency to waive that requirement, but that would be an exception.
The EPA recommended that the PSC be made a cooperating agency, which is something apparently you decided not to do. Could you explain why they shouldn't be involved?
Why the PSC?
Should not be as involved as a cooperating agency, as the EPA refers to it.
I'm not sure that they aren't a cooperating agency. PSC obviously has jurisdiction over pipelines. They're very actively involved in the pipeline. They have to have oversight over the construction of pipelines, as opposed to DEC, which has the authority over the drilling activities. But I'm not sure I understand the distinction here between a cooperating agency.
Well, this was an EPA recommendation, and apparently it's an official designation that you have to make.
Assemblyman, the PSC is an involved agency under seeker, and in fact, they presented an extensive presentation to our advisory panel. So I'm not familiar with the specific comments, but I'm not sure what EPA would mean by other, because they are an involved agency under seeker,
okay,
and they're involved.
Okay. Let me say that actually. As you might imagine, we have an awful lot of questions about this document, and a lot of the questions we're going to be sending to you in writing, and we'll expand upon that in our question, and then we'd appreciate a response. So
we'd be happy.
Beyond the questions that will be asked here today, we will be sending you a letter that'll have a lot more questions, and we'll include as much detail as we can in the questions, and look forward to your responses. With regard to waste issues, can you tell me why the regulation exempting natural gas and oil drilling waste products from the hazardous waste designation was adopted, and what testing was done to determine the composition of that waste?
I think the way the waste is characterized is less important, Assemblyman, than the fact that it's properly treated. These wastes, like fracking wastes and return water, would be classified as industrial waste, and they'd have to be treated as industrial waste. They'd have to be tracked, tested and tracked from the point of generation to the point of disposal. And I think the relevant question is, will they be treated properly? And we think that they can be treated in wastewater treatment plants that have approved pre-treatment facilities. They'd have to meet EPA and DEC standards. There's also the prospect of deep well injection. You know that in other states like Ohio, they use deep well injection to dispose of these wastes, and that's again permitted by EPA. But I think the important fact is that we would make sure with the waste plans that are required by drillers that any waste goes to a permitted facility, and that facility can meet all of its effluent standards.
Well, but I think the question is why should there be any blanket exemption at all? Why shouldn't it all be tested? And if it meets the definition of hazardous waste, be treated accordingly, and if it doesn't, it doesn't. Why just give a blanket exemption on it?
Again, I think it's the more important question is, can it be treated properly? Whether it's hazardous waste or industrial waste.
I'm going to ask the audience, please, it's not appropriate in any way. Okay, we're going to treat everybody who testifies here with respect. Please continue.
Yes, again, we focused in the agency on where that waste will go and how it will be treated, and the important, the real relevant point for us is that it meets all both federal and state effluent standards, and we believe that there is a treatment facilities out there that can handle the waste. None in New York right now.
Well, what are other states doing? Are there other states that have the blanket exemption, like you're proposing here?
Well, of course, it was exempted under the federal law, and many states have adopted those, like New York adopted the federal requirement. So I'm sure other states do have exemptions. But again, the exemption doesn't allow the waste to not be treated. It still has to be treated as an industrial waste and meet all federal and state standards.
From the information that you have, does any of the waste that's produced by the industry pose, and I'm going to use the language here that is the definition of hazardous waste, a substantial present or potential hazard to human health or the environment when improperly treated, stored, transported, disposed, or otherwise managed? Does any of the waste they produce meet that definition?
Thank you. The Clean Water Act requires that all industrial waste similar to this industrial waste be treated in the way that we propose in the SGEIS. There will be pre-treatment requirements, and there will be complete treatment based upon the requirements of the Clean Water Act as the wastewater is processed through these wastewater treatment plants. So in New York State, we have very, very protective water quality standards and a regime that regulates wastewater treatment and disposal. And those requirements under the Clean Water Act and our state SPEEDIES program will be met. So this is similar to other industrial waste in New York State. There will be a pre-treatment program that's required for the evaluation of these wastes. And we believe that based upon our overall Clean Water Act program in the state, this will be very protective of the environment.
On the staffing issue, there have been estimates, I think your own estimates, of the number of staff that you will need and the attendant costs. And obviously, staff at DEC has been decreasing steadily over the years. And so I guess the question has to be, where does the staffing come from? How is it paid for?
I've asked a panel to consider that question, Assemblyman. The panel consists of members of the environmental community, industry, local governments, and it's obviously a key question because I've said that we will only permit those applications that we have the staff to properly review them, monitor, and provide oversight. I expect that industry will pay for the costs of regulating this activity. And we're looking, the panel and DEC and other agencies are looking at existing revenue streams and the potential of enhancing those revenue streams. There is currently permitting fees in New York that are based on the depth of drilling that generate a certain amount of money. Substantially more revenue would need to be generated to fund the more than 140 positions initially that we've projected, and again, that's an estimate, but we believe we'd need about 140 new staff people to properly oversee the first stages of development of Marcellus Shale in New York.
And how would those staff numbers compare to other states? Let's say Pennsylvania, for example, which I think started out and then realized they had didn't look before they leaped.
Pennsylvania did substantially staff up, I would say, later in the process than they probably should have. They've added hundreds of people to their staff. It's a little hard to compare because they have a different regulatory regime than we do, Assemblyman, but I think it's fair to say that we're looking for comparable increases in staff to states like Pennsylvania, probably not as high because there is more of a resource in Pennsylvania and a larger area of the resource than there would be in New York.
I received some correspondence, which I'm sure you did too, from an organization called Physicians, Scientists, and Engineers for Healthy Energy, who say that the high-volume hydraulic fracturing has the potential to pose adverse impacts to the New York City watershed. I'm sure you're familiar with that correspondence, and I'm wondering how you would respond to it.
This is the letter that came in very recently.
Yes. I received it recently, anyway.
I've gotten so many letters in the last couple of days. Remind me what this
Well, that wasn't the
specific-
last couple of days. It was before that. It was a group of scientists, well, you know, as far as I can tell, and physicians, very reputable people who believe that there is, you're familiar with it?
Yes.
The potential for an adverse impact on the New York City watershed, even with what you're proposing. So I'm just curious how you would respond to that.
Yeah, I touched on it in my testimony, Assemblyman. The reason for exempting out the New York City and Syracuse watersheds is because they have a filtration avoidance determination from EPA. It is the FAD that is issued by EPA is reviewed every 5 years, and there is very precise and exacting requirements for continuing that FAD. They have very strict controls in both those watersheds on things that cause sedimentation, you know, activities on farms, road construction, any construction activities, period. It is the prospect, again, for the activity that would be associated with high-volume hydraulic fracturing that could tip the scale and cause EPA to reject a filtration avoidance determination for those two watersheds. And the cost, as I said, would be huge, $9 billion to New York City alone. It's not because it's filtered versus unfiltered. We don't rely on the filtered systems to deal with the problems. Our whole approach here was to prevent any contamination of water supplies, period, whether it's the New York City watershed or any watershed. We believe with the measures that we put in, including setbacks, on-site stormwater control, that we will prevent contamination from reaching the water supply. So it's not about whether it's filtered or unfiltered. It is, we've taken a very protective approach across the board, whether it's a private well or a city water supply.
Okay, I don't think their concern was what the EPA might do. I think their concern was that the science doesn't support the contention that the current plan is safe for the New York City watershed. But you know what, we'll expand on that in our letter to you and look forward to your response on that.
Thank you.
Let's talk about health issues. Can you tell me the extent, please, to which the New York State Department of Health was involved in preparing this document?
Department of Health has been intensively involved, I would say. Assemblyman, they have reviewed drafts, they've commented on our drafts. We've made changes to a draft to accommodate their concerns. They are not only an involved agency, they reviewed our draft every step of the way.
Okay, well, the EPA in their comments suggested, and I'll use their words, that the document needed a greater emphasis on potential health impacts. Can you tell me how those suggestions might have been incorporated into this document?
Well, again, our whole approach was to prevent health impacts. We have very, very aggressive controls, as I've outlined. Department of Health, again, was instrumental and played an active role in suggesting what those setbacks should be. And we are taking a preventative approach here. Gene, do you want to expand, please?
I believe you're reading from the EPA's 2009 comments, Assemblyman. In response to those comments and others, we extensively increased the modeling effort of air emissions. And we did take into account the worst-case scenario for air pollution that could be caused at a well pad. And carefully analyzed that and determined that EPA standards and state standards would not be exceeded, but that there was a need to take special mitigation measures with respect to particulates, and all of the measures are reflected in the revised 2011 SGIS, and you can see a very detailed description of the additional modeling that was done in response to EPA's suggestion.
Okay. We did a hearing on this subject, as I think you know, in May, specifically just on the health aspects. This committee did a hearing. And we heard then from a number of health professionals, scientists, who were pretty consistent in indicating that more research was necessary to determine the potential impacts, particularly with regard to endocrine disruptors and methane and a number of other things. So I guess I need to ask how confident you feel that those issues have all been taken into consideration adequately, along with all the other potential health impacts before drilling begins.
I guess, part of the answer to that, Assemblyman, is that the focus for health professionals has been on the experience in other states, which has not necessarily been good. We've seen problems in other states, and our SGIS was informed by those problems in other states, which we intend to avoid. So I don't think we are going to, I'm confident we will not experience the problems that have occurred in other states, because we've addressed those issues of shallow gas migration against, controls that needed to be placed on fracking fluids, storage of the fracking fluids, again, secondary containment in places where chemicals are mixed on sites. So I think we've been well informed by the practices in other states that health officials and professionals have been concerned with, and we designed our SGIS around those concerns.
Okay, I hope you're right. The state of Pennsylvania belatedly decided that they should have set up a health registry, and they, I believe, are now planning to do so. Would you support a health registry in New York?
Again, I would defer to Department of Health officials that's really not my call to determine whether we ought to have a health registry. In Pennsylvania, there has been a number of problems, and again, the focus has been on problems in other states, which we designed our program to avoid.
I appreciate that, and certainly would like to hear from the Department of Health on that. But this document is intended to take in a wide variety of considerations, including health and the socioeconomic conditions that were added. So I think it's certainly more than appropriate that DEC look into having a health registry and make their decision as part of this document, and not defer it to another agency, which ultimately doesn't have any control over this document.
Well, they may not have control over the document assembly, but they, as I said, helped produce this document.
Okay, well, I guess I'm asking whether you will go back to the Department of Health and have a discussion with them about a health registry and consider including that ultimately in this document.
I'd be happy to discuss that with them.
Thank you. Let's talk about jobs a little bit, because that certainly has been a big issue, one way or the other. And I'm going to actually make some reference here. So the person who's testifying later on in this hearing, who's an economist, she submitted her testimony to us ahead of time. So I had a chance to read it over, and she asked some very interesting questions, which I don't have the answers to, but since she's testifying after you're done, I think perhaps I'm going to ask you some of the questions that she has in her testimony, since I think they are appropriate questions to be asking. And then I guess if she wants to respond in some fashion, if she's here or listening, she can do so. But certainly that it's been a big issue, jobs. It's been an issue in other states. There's a lot of questions about, how many jobs will be created. I think there should also be questions about how many jobs will be lost. And I'm not sure that this document deals entirely with that aspect of it, but I'm going to read you some of her testimony, and I'd appreciate if you would just give me your response to it. And this is a quote directly from her. This is not from me. This is from her testimony. Since there have been many concerns voiced about the cost to communities, why was there no attempt to estimate such costs? Costs associated with the increased demand for community social services, police and fire departments, first responders, local hospitals, etc., should be estimated not simply mentioned and then ignored. The final paragraph of the assessment report simply lists a few of the costs to communities, but there is no effort to estimate any of the costs. Your response?
I think the SDIS did estimate some of the costs involved. In particular, it talked about the costs of maintaining roads and repairing roads and having roads be put into the condition so they could actually accommodate the heavy truck traffic that is associated with this activity. So I think there is a fair amount of information there about costs. It obviously is difficult to predict some of the costs, like social services and so forth, until an activity starts. But I think the SDIS made a good effort to try to get their hands around those costs. Again, a lot of the questions are based on the experiences of other states, which we do hope to avoid in New York.
Well, and based on the experience in other states, I mean, you make a very specific estimate about how many jobs will be created based on other states. So why is it not possible, based on information in other states, to develop estimates on community costs, among other things?
If I may, I think it's important to emphasize that this is a generic environmental impact statement. And the word generic is extremely important here because it's looking at impacts across a wide swath of the state for activities in many, many places. And there has to be an understanding of that it's in some ways going to have to be, by definition, generic. So even the cost estimates, even the estimates of job growth, we qualify and make it very clear these are all just estimates. We're just trying to make some informed predictions. But the EIS does not run away from the fact that there will be additional costs to communities in the area of emergency services, community services. We don't and can't predict them with precision, but we make it very clear that they're going to have additional costs. We face up to it and don't walk away from it in the document, and clearly make the point that revenues that come into localities or other revenue streams are going to have to offset some of those burdens, including impacts on roads and a lot of other things. And I think that's what an EIS should do. Should not, get away from anything, but actually face up to potential impacts so we're aware of them.
I appreciate that, but the document projects 17,364 jobs to be filled by New Yorkers. That seems pretty specific. I mean, so why can you create a number like that?
Well, those are all based on modeling, on economic modeling, and it's all in there, but I don't think any of us think that that is exactly the number of jobs that's going to be created. These are all just projections, but when it comes to actual how many ambulances a particular town or village are going to need to add, it's a much more difficult exercise to be able to do.
Which economic modeling could probably help you with there too, would be my guess. I mean, I just don't understand why you can be very specific about some things, largely based, it would appear, on data provided by the industry, but not so specific on but we'll move on. I mean, the same thing would apply, please. Same thing would apply to health costs. I mean, there's a lot of research, and I keep coming back to health because we did that hearing in May, and it was really, I have to tell you, it was pretty disturbing to hear some people who are these are scientists and academics with a lot of training in this field, and they did a lot of modeling. I mean, and they came in and they had information about death rates in areas of New York State where vertical drilling is taking place now. And they had models about air pollution that would affect not just the areas where drilling takes place, but downstate areas, New York City and Long Island and other areas. So public health is, I think, a huge part of this whole issue. And again, I'm wondering, and I'll read you again what her testimony is going to be. Why was there no attempt to measure public health costs? There was much research on the negative health impacts of shale gas drilling, and the public has repeatedly voiced such concerns. The costs associated with these impacts should be set forth.
I hate to sound redundant, but our entire framework and program here is designed to avoid those costs. It's to avoid contamination of water supplies and pathways that would expose people to the chemicals and that are used in this process, that it is a preventative approach. If you look at other states, I'm not sure it's fair to compare New York to Pennsylvania or Texas or Oklahoma, because we are being much more aggressive in the way we would regulate this industry.
I appreciate that, and I appreciate the answer. I would just make the observation, there is not a single state where this kind of drilling has taken place where there have not been significant health issues that have developed. And I hope you're right, that what New York State is doing will help to prevent a lot of those issues here, but I'm going to pretty much guarantee you they're going to happen. And saying we think they're not going to happen or that they will be minimized does not put us in a good position to be adequately prepared to respond to them when they do occur. So that's why I suggest the health registry, and that's why I think we have to be a little better prepared than we seem to be to respond to these things when they happen. It's an observation. Another question, I'll continue. Another question from her testimony. It is well known that extractive industries create a boom and bust cycle for communities. Why are the costs of a long-term bust not estimated in this assessment? The activities, as you know, will could extend over a 30-year period of time. And I think the SBIS acknowledges that the number of jobs will go up and then it will decrease over time. All of that is acknowledged. I'm not sure, Assemblyman, why, and again, I have a hard time characterizing that as a boom and bust, because it will be a gradual ramp up. There will be a number of years of peak production, and then there will be a tapering down as that particular resource is exhausted. Again, the SGIS acknowledges it. I'm not sure what you can propose as a mitigation to that. That's the nature of the industry. So. Okay, another question. Why was some research regarding the impact on property values summarized without mention of the fact that there have been reports that banks may not issue mortgages on properties with or near a gas well? And I think we're going to hear from a banker later on today on that subject. But we've been told by the industry that, and as I think you're well aware, that because of federal law, there are going to be people who won't be able to get a mortgage. So why is that not considered as part of the impact on property values?
Already happening.
Assemblyman, I'm aware of the problem, and I guess the problem is really with the secondary market for mortgages, not the initial mortgage market, and it is something that we should explore further. I don't have a good answer to that. I'd look to see what's happened in places like Pennsylvania. If it's been a problem, it must be a problem there, where lots of drilling is going on, but it obviously is something that we should look into in more depth.
Okay, so you're saying that this is something you will look into in more depth?
Absolutely.
Okay. Next, I think there are only two more here. I won't belabor the point, but I think these are all good questions that she raised. And it is clear that E&E being the company that performed this research for you, focused only on benefits, and the estimated benefits are exaggerated. All of the employment, income, population, and tax revenue projections in the economic assessment are dependent on the natural gas production assumptions. If production assumptions are exaggerated, then employment, income, population, and tax revenue projections will all be exaggerated as well.
As I mentioned earlier, they took very conservative assumptions. They gave ranges. When they looked at the economic impacts, they used a low development scenario and an average development scenario. That's why they came up with estimates of 6,000 jobs under a low development scenario and 24,000 jobs under an average. Those are direct jobs. So it's obviously a huge range, but they went to the more conservative side of the equation to evaluate the jobs.
Okay, well, I think that leads to the final point I'm going to raise from her testimony, which is this, and again, this is quoting from her testimony. E&E has taken production assumptions from the industry, specifically from Ioga, New York. Why were the production numbers provided by Ioga, New York for the analysis not questioned and reviewed in light of the fact that there are indications that the industry may not be entirely truthful about production estimates?
Well, I think this is one of those cases where we can look across the border, and we've seen the amount of activity and production. It's pretty well documented. I don't think there is, a real question about how much has been drilled and how much is actually being produced in other states that are actively involved in high-volume hydraulic fracturing. So I think, the industry is the one that's out there drilling the wells. They have to report production. So we are using the best information that we have available to us. And I don't know why that would be, why they have an interest in overstating that. They're the ones that are going to have to come in and invest millions of dollars in a well to drill it. I don't think they'd be involved in the activity if they weren't going to get a return from that.
Well, I understand, but I think the question is that the production numbers affect all the other estimates that you're using.
I'm sorry, I got distracted here.
I think the question that she's posing is that the production numbers that you use are coming from the industry, but they affect all of the other numbers that you have in your report. And so I think she's suggesting that they should be at least verified and not accepted at face value, which does not appear to be something that E&E undertook.
Yeah. On the economic side, we used I'm sorry the mic has been off the whole time. The numbers that we used for economic analysis were the conservative numbers. The numbers we used to evaluate the potential impacts were the high numbers. So we exaggerated the analysis on both sides so we wouldn't overstate the economic impacts, and so that we wouldn't underestimate the potential impacts. I mean, I think we took a very conservative approach across the spectrum on the SGIS.
Okay, different subjects. Fracking fluids. Any changes in this document from the previous one with regard to disclosure of the fluids, and what information from that disclosure will be available to the public?
I'm going to let Steve talk about this. In general, Assemblyman, we will require full disclosure. As you know, there is a law that protects trade secrets, but from a layman's point of view, and again, Steve can give you a better legal answer, we will provide the information about the chemicals that are used to the public. They may not, again, if a trade secret is requested and we agree that there is proprietary information involved that shouldn't be revealed under current New York law, we will still provide the ingredients, the specific chemicals to the public, but maybe not in the exact proportions, so that people wouldn't be able to figure out the exact formula, but they would know all the chemicals and approximate volumes that are involved. But I don't want to overstate my expertise on this, so I'm going to defer to Steve.
The Commissioner answered that question pretty thoroughly. The one point I want to make is, as to the department, we will get the precise chemical names, the precise everything. We will have that information, so in case of a spill, we are able to respond. The only place where trade secrets will come in is for the disclosure to the public, and in that case, we are going to maximize disclosure to the public as much as we can of precise chemical names and everything else without giving out actual formulas to maximize public disclosure. We think that's extremely important part of the regime we proposed in 2011. And if somebody claims trade secret, we are going to really put them to the test to show why that's the case. We're not going to just take that on faith.
Okay.
If I may supplement that in one respect, there was not a great deal of change with respect to disclosure because the 2009 draft was very progressive in that area. The big change in the new draft is a requirement that drilling operators evaluate alternatives that are less toxic. We want them to check the literature on every new development in the event that a new constituent for fracking fluid can do the job without providing any toxic hazard. And wherever that's possible, that's going to be required.
Okay, let's talk about the regulations which you mentioned in your testimony, which are taking place simultaneously, and you indicated that you felt that was an appropriate activity, but it's nevertheless not something that's commonly done by agencies. And so I guess I have to wonder why the decision would be made to do that in this particular case when it is not common practice, and when it certainly does create the impression that there is kind of a rush to bring this, intended or unintended, that there is a rush to bring this to a conclusion.
This still boggles my mind a bit, Assemblyman, because the regulations are something that many from the public wanted to see. As you know, the agency was not always committed to doing regulations. We thought we could implement, and still do to a large degree, all of the requirements of the SGIS through permit conditions. But many people in the public felt that regulations were appropriate. I agreed, committed the department to do regulations. The regulations go hand in glove with the SGIS. They are intended to implement the provisions in there, the specific requirements with regard to setbacks, the prohibitions in certain places that have been proposed. So they will not look all that different from the SGIS. They will be, again, a complement to it. So it seemed to me that there was no reason to go through two separate public processes and public hearings in particular when the topics are virtually the same. One is implementing the other. If we get, which we will, we're going to get public comments on the SGIS and the regulations. When we make amendments to it, when we change it, which I'm sure we will, we made lots of changes from the 2009 draft. We value the opinion of the public and all of the comments that we get. We will make changes. We will make conforming changes to the regulations. So instead of going through the process twice, and again, it's time intensive, it's staff intensive, why not do it simultaneously? So that's, again, there was no effort here to try to fast track, to try to circumvent the public input or short circuit the process. This was just a process that I thought made perfect sense because the two go hand in hand.
So what do you believe then would be a reasonable time frame, or what is the time frame you have in mind for this whole process, including the issuance of permits?
Well, it's, I always avoid trying to predict a specific time frame. It depends in part on the volume and the content of the comments that we get. We obviously will, as of now, the comment period will end, I think, December 12th. Then the agency has to review and respond to all those comments. We finalize the SGIS after we've completed that. It will be sometime in 2012. And we then can finalize both the SGIS and the regulations. But, to the precise timetable, it is hard to predict.
Where in that process would the issuance of permits be?
Well, after the SGIS is finalized and published, you have to do a finding statement, and any time after that, permits could be issued. And again, in part, it will depend on resources. If the agency doesn't get additional resources, we will process very few permits. If we get the resources necessary, we'll be able to process more. But as you know, we will not consider any of the permit applications that are in or that may come in between now and then until that process is complete.
Okay. Earlier, in response to another question, you mentioned traffic, and there was something in the document that just stood out a little bit, which is that the DOT is estimating 1.5 million heavy truck trips in a peak year, but the document estimates a little over 500,000, or about a third that number. Why would there be such a disparity between DOT's estimate and this document?
I don't know, to tell you off the top of my head. I'd have to look. It may be that the DOT numbers are based on the earlier SGIS. I don't know where the disparity is. Department of Transportation obviously reviewed all of the traffic and transportation issues in the most recent revision, and were, comfortable with them. They didn't ask us to change the numbers. So I'm not sure where the disparity comes from.
Okay, well, maybe we'll follow up with DOT on that one, too. Earlier, when we were talking about jobs, I made a brief mention of jobs lost, which I don't think was something that was given, doesn't appear to have been given an awful lot of consideration. Yet I'm hearing all the time from people in agriculture, sportsmen's groups, interestingly enough, for organic farming, tourism, winemakers, that they believe there's going to be a negative impact on their industry and a consequent job loss. But that does not appear to have been given a significant consideration in the document. Could you elaborate, please, on what sort of work was done to look into the concerns that have been expressed about jobs that could be lost?
Again, the emphasis will be on, preventing job loss, and I think preventing problems associated with hydrofracking will be the #1 way to prevent jobs from being lost. Obviously, very difficult to predict how it will impact different sectors of the economy. I would say on the agricultural front, as you know, farms in many places in New York and across the country are suffering, and it is, many folks in the agricultural communities, welcome the opportunity to sign leases and supplement their farm income. And Ag and Markets is obviously an involved agency here and will help craft best management practices so that if and when drilling occurs on farm, it's done in a way that minimizes the impact of the farm and lets the two coincide or coexist. It is more difficult in things like the tourism industry to predict how it will impact areas where there is heavy tourism. That's something we will consider when we receive permit applications, where they propose to site specific well pads, whether they are in or near scenic areas, which are all well documented in the SGIS. We may ask them to move the locations of those so that they are less visually intrusive. So there are things we can do in the review of individual permit applications that will minimize the impact. Again, I'm not saying there won't be impacts. There may be, but again, very hard to quantify and get your hands around. But no question that there will be impacts to different segments of the economy.
I appreciate that, but I think the question is why that issue, there was a concerted effort made to estimate jobs that would be created, but there was no examination in detail of jobs that would be lost, and that I think would have been a more than appropriate thing to look at as part of this document.
Mm-hmm. Again, I think it's a very difficult thing to assess the jobs lost, and again, the things like being able to sequence permits applications so that activity is not going on in any particular area in too aggressive fashion, so that there would be visual, noise, and other impacts which could affect a tourism industry. Those will be things that we'll look at in our review of permit applications, and we may impose, again, permit conditions or impose timing sequences on drilling activities to minimize those impacts. If those things are done, you minimize the impact on things like job losses. But how you evaluate that specifically is going to be very difficult.
I appreciate that, not to belabor the point, but it may or may not be difficult to assess the number of jobs that could be lost, but when you don't make an attempt to make the assessment, then I think that's a concern, and it gives me, at least, not speaking for anybody else, a bad feeling that here's an effort made to pump up the number of jobs that might be created, but no consideration given whatsoever to jobs that will be lost. And quite frankly, there will be jobs lost. I don't see how you can look at one without looking at the other. But again, not to belabor it. Let me point out we've been joined by Assembly Members Latimer, Crespo, Corwin, Schimmel, and Abenanti. Last question that I'm going to ask, and I know I suspect there will be others, is on that of burden of proof. And my understanding is that in Pennsylvania, the burden of proof is on the industry, that they did not cause alleged contamination. But in New York, as I understand it, the burden of proof is on the property owners to prove that the industry caused the alleged contamination. Is that true, and does this document address that or have a recommendation to make on that issue, one way or the other?
Assemblyman, I'm not sure of the precise issue. Obviously, we have a comment process. To the extent comments like this come in, we'll look at them. It's a legal issue. Some of it may be just the common law of the state of New York, and there's maybe nothing we can do about it as a pure legal issue about whose burden of proof it is or isn't in a private lawsuit.
Well, if it's the law, then the law can be changed. So obviously, there's something that can.
Well, the law could be changed.
That's why we're asking the question.
But what I'm saying, but I think it's very important to understand that we're doing a couple of things that almost make that issue academic, which is that we are requiring that there be testing within a certain feet of these well pads, of any wells that exist, before the drilling takes place. So we will have the data. Because one of the issues that the drillers will say is, how can you prove, well owner, that this contamination didn't predate our activity? Well, we deal with that by requiring that the drillers, at their expense, test all those wells before they drill. And then, I think it'll be much more easily shown if, in fact, the well was clean before and now there's gas in it, that there's a cause and effect. So that's how we intend to deal with it, and I think that's a very effective way.
Well, I appreciate that, but that doesn't change the underlying. Is the premise? Was the statement I made incorrect? Is it incorrect that the burden of proof, as existing law is in New York State, is on the property owner?
I believe it. The burden of proof in a private lawsuit, if somebody wants to prove damages, like in any other tort case in the state, in any area, is on the person who is asserting the damage.
Well, I'm
it's
told
no
that
different in any other situation of pollution in this state.
Okay, well, I'm told that in the state of Pennsylvania, it's the other way around. Would that be an inappropriate change? Is there anything in this document that addresses that, or that you would have a feeling about one way or the other?
From my perspective, I'm not familiar with the Pennsylvania, with any difference in burden of proof in Pennsylvania, but if you provide us, your comments on that, we'll certainly look into it.
Okay, we'll add that to the letter we're sending them. Ms. Lifton.
Thank you. Thank you very much, Mr. Chair. Thank you, Commissioner, for being here today. Sure. For everyone else attending. So let me start with sort of a general question. I'm glad the mic got turned on because I missed some of, I kept saying we've got just bad acoustics in here. I'm having a very hard time hearing what some of you were saying. I don't know whether people out there did as well.
I have the same problem.
And I want to make sure my mic is on as I do that. Can we just let's start with the general question of executive order. It was 41, Patterson's executive order 41, and then Governor Cuomo came in and made it his first executive order 1, that continued Patterson's executive order saying that we must not just do an update, you use the word update in your testimony, a comprehensive review of this matter, of this whole SGIS. In this industry in New York. What does that mean to you, Commissioner? Comprehensive review. What does that mean under our state law and under SECRA, right? We're talking about SECRA here?
I will tell you what it means to me as a layperson. It means that you look at all of the potential impacts and also potential mitigation measures. From across the board, and it involves environmental impact as well as consideration of economic and social impacts as well.
Does it mean cumulative impacts?
Yes.
Have we dealt with the issue of cumulative impacts on air quality, for instance? Your aide here, I'm sorry, I haven't registered your name, sir, I'm sorry. talked about looking at the air quality at each individual well pad. But we know from reports and from what's happened in other states that, you could have hundreds of well pads and wells in a county. Is the issue of cumulative air quality important, and are we looking at that in the SGIS? Have you looked at that?
It is important, and I believe we did look at the cumulative impacts, again, based on modeling on the number of anticipated wells. And because we were looking at potential adverse impacts, we looked at the kind of the more aggressive scenario, the high scenario, if you will, of the number of wells that could be drilled, and modeled what the air impacts would be and what we would have to do to mitigate that. So yes, I think we did do a very thorough job on air quality impacts, the cumulative impacts of drilling in New York.
I'm hearing different assessment of that from people that have looked closely at it.
Well,
and part of the problem here,
we're interested in
Commissioner,
hearing that too.
And part of the problem is that it's very hard to look very closely at this whole document, as you know. I want to put out a little complaint about the process here on putting this SGIS out. You had said, we're going to put this first piece of most of the document out, 800, 900 pages out, and then we're going to bring in the socioeconomic impact study. And that's just going to be an addendum, and there's no problem putting it out in this fashion. But in fact, that socioeconomic impact study got pieced into the larger document in many cases and many parts, and it threw off the whole document. Anyone who had been trying to read and assess that document and follow it and, come up with responses to it found themselves totally thrown off when the addendum came out. It was not of a piece, and it was in fact, the document was really only complete once the final document came out. I would argue that it was a very fragmented situation for anyone that was really trying to look closely at that document and try to respond to it. Even section numbers changed. There was no organized way to really look at that study.
Could I respond briefly? I take full responsibility for the way the document was rolled out. I think I came to the conclusion that it was better to put out the document sooner rather than later, even if sections weren't adequately covered and needed additional study and analysis. So I apologize if some people found it difficult. I just thought it was important to get as much of the document out before the public eye sooner rather than later. It would have meant delaying the document, several months, and frankly, we had most of the document completed, but there was areas like the socioeconomic areas that I felt strongly needed a harder look than it had initially. So, we also, when we put the final draft out in September, we did try to highlight as much as possible all of the changes between the two documents so that people would know exactly what was added and where. I thought we made a good effort at that, maybe not good enough.
I think it was a problem for people that were trying to seriously assess the document and respond. It was for me and my staff, so I can only imagine it was for the general public. In terms of health impacts, as you know, again, that was a piece of that's a comprehensive review. It's health impacts. Clearly, health impacts are critical. The EPA had called for DOH not just to be involved. I don't know how we define involved exactly, but I believe they said they should be a co-lead agent. We called people that responded to that first document, said these issues are so important to New Yorkers that the Department of Health ought to be clearly delineated as a co-lead agency. What's the distinction in your mind between being involved and being a co-lead agency? What does that really mean practically for the public? Because you're saying there are things, but
there's two seeker experts at the table here that I would defer to.
Okay. So the questions come up that we ought to have a registry, and you're saying, well, I can't talk about that.
No, I didn't say I couldn't talk about it. I said it is something I will talk about with the Commissioner of DOH and staff at DOH. I think my point was simply that DOH was very involved in the process, in the product, and I think DOH feels very comfortable with the product, that the approach we've taken is a preventative approach, that we are limiting the potential exposure to the public to the to the downsides of hydrofracking.
Is
Are we
it-
eliminating them? No. There is risk involved in every activity we permit at the agency. And this is another one. There are risks involved, but we think we have minimized the risks and minimized the potential for public exposure.
Is it a matter of an agency saying, we're responsible, our name is on this, we are responsible for some of what comes out in this document?
Well,
Is that
we
what it
want-
is? You were going to speak, I think.
Yep, I'll let him speak in a moment, but, someone had to take responsibility. The mineral law is within the Department of Environmental Conservation, so we were the lead agency, but we worked very closely with every other agency that had a role in this, the Department of Transportation, Department of Ag and Markets, Department of Health especially. I think every draft was reviewed, every change in every draft was reviewed by the Department of Health. We consider them our partner. We think it's very important that, and I know it's important to the governor, that New York speak with one voice. So to the extent there was any disagreements, we ironed them out, we satisfied concerns. So I don't know whether, co-lead here was necessary. We worked hand in glove with them again. And
From the law perspective, a co-lead is certainly a way to go. In this case, the lead agency is defined in the statute as the agency primarily carrying out the proposed activity. In that case, that is clearly the Department of Environmental Conservation. We would be issuing the permits. We are issuing the regulations that govern the activity. The Department of Health in this case is, I think, clearly an involved or interested agency. But purely when you get beyond the legal connotations, the fact of the matter is, as a practical matter for us, it's a distinction without a difference, because they are our partner. They are heavily involved. Their concerns are our concerns. And so it doesn't really matter in this case of this generic environmental impact statement.
In fact, the Commissioner of Health was asked point blank, won't you be the co-lead by certain stakeholders? And he replied in a letter that because of the Department of Health's extensive consultation with DEC, that it would add nothing.
They were de facto
If in fact
co-lead, if you will.
DOH were co-lead, and he recognized that DEC issues the permits that are at question here.
I'm very concerned about the health issues. I went down to Pennsylvania about a year ago. I went down again a week or two ago and spent the whole day talking to various people down there, people in Bradford County and Susquehanna County. And it's very troubling what I heard and what I saw. Are you aware, Commissioner, that there are people, I'm sure you've heard, that there are people in Bradford and Susquehanna counties that have barium poisoning and have sought medical help with the serious health consequences of barium poisoning? Are you aware that there are people in Bradford and Susquehanna counties that are suffering from barium poisoning?
yes, I have. I understand that.
I know you went down to Bradford, or to, I don't know which, the explosion you went to see was in
Leroy, Bradford County.
which is Bradford County. I get the two counties mixed up. You went down, you personally went down, and I'm sure you went with staff, but you personally went down to look at that
I did.
explosion. And incident, ended up being called, but did you talk, when you were down there, did you talk to, besides the industry and saying what happened here and what can New York do to avoid this sort of accident, very serious accident that had 7 families evacuated from their homes, that have at least 3 of those families now with total water contamination, have water buffaloes or are on bottled water since April, since that explosion? Did you talk to any of the residents, or have you talked to any of the residents, or has your staff talked to any of those residents in that area who are suffering from barium poisoning?
I didn't talk to residents, Assemblywoman. I did talk to state officials from the Department of Environmental Protection, and we met with soil and water conservation staff who have an important role in the program. So we spent most of the day down there talking to both Chesapeake, who brought us on a tour of the site, and they were the owners of the well that had the problem, and the public officials there as well.
So you talked to Chesapeake, you talked to state officials, but you didn't talk to the residents who are saying their health has been badly damaged from?
No, I did not talk to the residents.
But you're saying that we're gathering information, we're looking at other states, we're trying to figure out what's happened, and...
What we were doing, Assemblyman, was trying to figure out how we could prevent those problems from happening in New York, and I think, again, that's the approach we've taken across the board.
So tell me what the state of Pennsylvania, the DEP, has said about why those people have polluted water, contaminated water, and what, if anything, they're doing to help them. People say the state is mostly walking away from them, as is the industry saying, it's not our problem, we're not, you're going to sign a non-disclosed statement, you can't go out and talk publicly about this, but we'll bring water to you. What is the state saying about that? What is the industry saying to you about that? What do we really know about what's happening to the people in those counties in Pennsylvania where there's full bore, as you say, at a sprint, the industry is rolled out?
I can't possibly speak for Chesapeake or the Pennsylvania Department
You said you
of
spoke, I'm sorry, you said you spoke to them.
But I can't speak for them. I mean,
Okay.
they're the ones that are responding to
But-
this incident. What I can tell you is that what I saw there was a containment area around a well pad that was, did not appear to me to be properly constructed, that this incident could have been avoided if it was properly constructed. And it's precisely those types of requirements that would be required in New York State that I think could avoid that type of situation. So I don't think we'd find ourselves in New York in a situation where in the situation they found themselves in Pennsylvania.
Also,
I've got
there
a-
was a failure, if I may, I'm sorry.
Sure.
There was a failure of the Pennsylvania Department to inspect the equipment prior to that incident. And the staff were surprised to learn that in New York State, this kind of laissez-faire approach just is never permitted, that we have inspectors from DEC to go out to the site to check these systems before the actual operation occurs.
I'm a little confused, Commissioner. You've said that you're looking to other states for their experience, but we're not getting back any kind of health data, any reports of barium poisoning from the state right next door to us that is the most recent experience. As we've been looking at this industry for 2 years, I would think we'd be very aggressively either asking the industry or asking the state of Pennsylvania to put together reports on such serious matters as barium poisoning, reports of barium poisoning, and I'm sure probably other serious health issues, perhaps premature, birth defects. There's talk down there about babies being born with holes in their heart, things like that. All admittedly anecdotal at this point, but anecdotal because we're not asking for studies. No one seems to be producing real studies. Are we just going to go on that and not get real data about what's happening to real people? Are we not asking for that?
My job is to prevent that from happening.
Okay. Do you know that one of the people?
Quiet, please.
Are you aware that one of the, at least one, maybe more, of the 7 families around that blowout was about 570, 580 feet away from the well? And we put 500 as the setback, but they were almost 600 feet away from the blowout and have water that has meant they cannot literally, they were going to sell their home. And it had about $200,000 of value on it. The realtor said, sorry, you're going to have to take it off the market. Your home is now worth $20,000. That home was almost 600 feet away from the well bore.
And under a completely different regulatory regime than we're proposing in New York State.
On continuing this just for a moment, are you aware that Guthrie Hospital put out an initial report a few months ago with page after page after page of, that just was one great concern after the other about the number of injuries, the number of sick people, the amount of traffic, people couldn't even get to work, couldn't get to their hospital jobs. They were losing people volunteering for ambulance corps. They were burned out. The hospital, you've got the Department of Health involved. Are they putting together a plan to really look at the issues that we're seeing coming out of Pennsylvania? And in addition, is anyone going to be looking at training health officials on the front lines? Our county health departments, according to the Carty report, which I'm sure you've seen, the report out of Cornell, says they interviewed county health department officials who say they're pretty much totally unprepared. They're getting no plan, no assistance, no nothing, no training from the state. In Pennsylvania, these folks went to doctors with their hair falling out, with shakes, and the doctors put them on anti-anxiety drugs until they figured out at some point that, and these people were still drinking the water that was causing the barium poisoning, as the doctors didn't even know how to diagnose what was wrong. So I'm wondering, again, to what extent we're looking at preparations for the not just likely, but almost guaranteed health impacts from drilling.
Concede that they are almost guaranteed. I'd reemphasize the point that we do have a completely different regulatory regime that we're proposing from other states that have been involved in this activity. I think, I can't restate that enough. We are proposing a very rigorous regulatory regime. We have a long history of drilling in New York, and we have a very good track record. And we're enhancing everything that we've done in the past to prevent accidents from happening, to prevent exposure to the public. I think on the local side, we are sensitive to the fact that there are going to have to be enhanced things like training, and we are looking at this and looking at the resources that would be available to local governments to train local officials, both emergency responders as well as healthcare professionals.
And presumably that would be done prior to the industry rolling into town, right? Where's the money going to come from to go to county governments and county health departments, and frankly, the county to, I guess, get the roads ready for all the trucks coming in? Where are the resources going to come from?
There is a local tax in New York. The ad valorem tax would raise...
Before the industry comes into town, I said. I mean, you got to be ready before, right?
In some cases, it would be prudent to prepare before, absolutely.
And where's the money going to come from for local governments to prepare before
we hope
drill
to have
rig comes into town?
A whole series of recommendations that will be input into the executive budget process that will address both state and local needs.
Money is going to come from the state to local governments before?
I didn't say that. I said we are looking at how those impacts, how the resource needs associated with those impacts will be addressed. And it is both a state and local budget issue. And it's, again, I've emphasized that the industry is expected to pay for this, and we are looking at revenue streams that would be imposed on industry to pay for both the state and local impacts.
But of course, the money doesn't come until after the gas starts flowing, right? How can you fix the roads for the trucks coming in? I don't understand the chronology here. That baffles me, how that chronology works. And we know, of course, that local governments are broke, right? We all know that, and the state has just put a tax cap on local governments to top it off. They were already struggling.
On the issue of roads, we are expecting that applicants would be working with local municipalities on road use agreements. And locals do have control over local roads. They are specifically charged with that. So, and that's been the experience in places like Pennsylvania and other places, is they negotiate road use agreements because roads is a big, substantial issue. Both the industry and local governments know that many local roads are not in the shape that they need to be to accommodate the truck traffic. And it's in everyone's interest that they be upgraded and maintained, and that there is revenue, again, paid by industry to the local governments to address that.
Okay, thank you. Commissioner, just one more point here, if I could, and I'll hope maybe I can come back. I've got a lot of colleagues here, so. To what degree are you looking at the E&E impact study and the Christopherson study. We have sort of almost competing studies at this point, if you want to call it that. The Christopherson report clearly says that there are job losses. The current economy gets crowded out when the industry comes in. Yes, there's a boom. You said you're not so sure there's a boom and bust. Every study is saying boom and bust. I was surprised to hear you say it's not so clear there's a boom and bust.
I acknowledge that it accelerates over time and it will descend. I mean, everybody acknowledges when you're extracting a natural resource that it is a finite resource. It doesn't continue on indefinitely. There is approximately a 30-year cycle from the beginning of the drilling process to the end of the well production.
So I'll just try to quickly ask you a couple questions on the studies. Can you explain why, in choosing the consultants of E&E, that you went through a generic bid process through Office of General Services, rather than an open process that would have allowed academic institutions as well as other private contractors with more specialization, frankly, in the area of socioeconomic impact studies? You know, it's already been pointed out by the chair that the E&E study is mostly just, here's some potential benefits, some loose numbers on benefits, and really nothing about the potential costs and nothing about the it's all economic. The socio part isn't there. Where is the information on crime, which I'm hearing a lot about from the people in Pennsylvania? The number of rapes, unidentified assailant rapes in both counties have gone up dramatically, according to people I spoke to. It was unheard of before. Now it's a real issue. People are feeling afraid, I can tell you that. Changes in crime, illness, homelessness, traffic accidents, racial and socioeconomic impact, makeup of community population. Community population, does it stay the same? Does it go up? Does it go down? The Christopherson study speaks to that. I don't think E&E does. Rental costs. Housing is a huge issue. What's happening to housing? We're hearing in Pennsylvania that people are being pushed out of their housing by high costs, and more people are becoming homeless.
I think the E&E report, which is DEC's report, does address many of those issues. There was a substantial discussion of housing, of crime, of the socioeconomic impacts.
Can I get more?
They may not, again, there may not be measures there to solve all those issues, but they are fully discussed and acknowledged. It was not our intent to, again, push any of those issues under the rug. They are discussed.
They acknowledge they're there, but that's different from doing a study to say this is what actually happens, and this is how local communities can prepare for that. Can you tell me about the generic bid process? I'm interested in the process issue here, rather than an open bid process on this consulting. And I'm not disparaging the company, E&E, they may be a perfectly fine company. I just, it's always important for the state to be getting neutral information, and I'm curious about that bid process that went on there instead of an open process.
As I understand it, the state has a number of standby contractors that did have to go through a bidding process in order to be selected, and E&E is one of those contractors that was available on a standby contract. E&E has an excellent reputation. They do have they're worldwide. They have an excellent staff, and we, as far as I was concerned, they were an excellent fit for looking at the issues that we looked at. So
some people have been concerned, that they were too closely tied to the industry, and it might have been good to have an open bid process that had more neutrality. Perception matters, I'm sure you know, Commissioner.
E&E consults for everybody, environmental organizations, industry. They have no interest in taking sides. They are a consultant, and they work for everybody. But they are they're a great group of professionals, and I think their work was excellent by and large.
Thank you, Commissioner.
Thank you.
Mr. O'Donnell.
Thank you very much, Mr. Russo. Very nice to see you. I'm going to begin by a brief follow-up on one of Ms. Lifton's questions. I want to make sure I understood you correctly. Are you saying that a local government, a local town, or local county can make a determination that the cost to their roads and infrastructure is X amount of money, and they could tell the company, you have to pay X amount of money, and if the company refuses, those local entities have the right to say, you don't get to do this?
the ultimate authority comes back to us at DEC. That is a permit, that is something we would consider in our permit process. So if we don't believe that a road maintenance agreement is in effect that will provide for adequate roads, then we wouldn't issue the permit, or we'd condition the permit to our satisfaction to make sure that that happened.
Well, I think the real question is who gets to decide. Are you telling me that your judgment about what will happen to XYZ town or county will supersede that town or county's estimation of what those costs are? Because what I fear is they will come back with a realistic cost, and of course the industry, which has a lot of money for very nice commercials. Have you seen their commercials? They're lovely. They're bucolic. I would like to rent a house where they film their commercials just for the beauty of what they're filming and saying, look what's under our ground, it's going to be lovely. So I believe there's money there for them to come back and say, we don't want to pay X amount of money. But if you don't allow those localities to be the final arbiter of them, then you're taking away the local people's ability to make sure that their lives are protected.
Could I answer?
You certainly may. Have you seen the commercials, Commissioner?
I don't watch much TV.
Oh. That means you don't watch any baseball, because they're on every 30 seconds on the baseball games. Go ahead, yes.
Okay. First of all, what a local government tells us about the conditions of the road and how much they think will cost is obviously extremely relevant. We also provide those transportation plans to the Department of Transportation, our sister agency, who has to look at them and be convinced, again, and when they have plenty of expertise in this regard, to both know if a fair evaluation has been done of the condition of the roads and an evaluation of what's needed to upgrade them, to make them, to put them in conditions so that they can accommodate the increased truck traffic. So we have, from my point of view, I don't care about the cost. If it's necessary to upgrade those roads, then we have to be satisfied, and DOT has to be satisfied, that they're going to be upgraded to accommodate whatever truck traffic is going to be generated by the activity.
Well, although I don't represent those towns or counties, I want those towns and counties and those residents to be satisfied too. And so I actually would prefer them to have that decision, not somebody else. Let me ask you a quick question about data. Data is a fascinating, manipulation of statistics is an art form. I know that because I represent Columbia University, and that's pretty much all they ever do is manipulate statistics. So, it's difficult.
Continue to represent them?
I get represented to fight them, sir, so I do a pretty good job. It is very difficult sitting on this side to try to balance the interests when the information is so questionable. So you have a right-wing tabloid newspaper that puts that this will create 150,000 jobs and $13 billion. Right, that's what they put out in their newspaper, and yet you say you look to other entities, other states where this has been done, and in Pennsylvania, the data from the Keystone Research Center and the Commonwealth's own Department of Labor show that over the 4 years in Pennsylvania, a whopping 9,300 jobs were created. So the question is, who do you know and how do you believe what that is when there's such a campaign of disinformation out there? And so in the balancing act of what we try to do, it's very difficult to accept what people come up with, because when we look just across the border, the reality was profoundly different from what the very same people were estimating would bring in jobs into that state. Mm-hmm. So how do we deal with that discrepancy?
Well, I think the way we dealt with it is we took very conservative numbers. We took the number of anticipated drilling permits that we anticipate in year 1, year 2, and out through peak production in year 5 or 6, and use those as assumptions. They are, I think, most people agree, Assemblyman, that have looked at these, that the estimates we used were indeed conservative when it came to generating the economic development statistics, if you will. And the range was obviously huge. I know that there was fun made of the specific number that they came up, but the fact is that the low range to the high range was from 6,000 to 24,000 jobs. We're not saying it's going to be 24,000. I'm not going to tell you that there's going to be $2.4 billion in economic activity. It may be much less, and the report states that it could be considerably less. So I think, we've tried to be as conservative as we possibly could when it came to things like economic development, which is not the department's primary concern here. Jobs are important, yes, but our responsibility is to regulate the industry to protect the environment and public health.
Okay. Your predecessor testified at a similar hearing, and I suggested to Mr. Granis that maybe what we ought to do is bond for this process. Force the companies to pay a bond, because it seems to me that if you're under the belief, which I can tell you I don't agree with, that you have the capacity to do this and do it safely, then the risk is infinitesimal. And if the risk is infinitesimal, the free market bonding would be infinitesimal too, right? So it seems to me that if you're going to go out, let someone go out there and do this process, why don't we let the free market operate and simply say, you have to bond for the potential damage you might do? And in the case of injury to families that Ms. Lifton raised, that could be a lot of money. Okay? And so, in the end, why don't you force the companies to pay a bond to cover the risk of what they're trying to make profit off of?
I think, financial assurances is an important issue, and we ought to consider whether bonds or some other mechanism ought to be used.
Well, I would suggest that you require it, sir. That's what I would suggest.
Thank you.
I just have a couple more, very brief, Mr. Sweeney. Earthquakes. We had one in New York in the summer. The gays got blamed. We get blamed for everything. It's okay. We had nothing to do with it. I want to assure everyone, but we get blamed. And because, it started in Virginia. They're not so good with the gays in Virginia. But anyway, it moved up to New York. And there are other places in the world where they've concluded that this exact process could, in fact, be connected to earthquakes. And so I wonder whether or not you've addressed that, and if you haven't addressed that, how will you address it? And more importantly, what will you say if it turns out that that is in fact a connection between shaking the ground deep under the earth and what happens to people around?
I'm going to let Gene, we talked about this yesterday, and I know Gene's up on the topic.
There is in the SGIS a discussion of the scientific evidence pro and con. We concluded the weight of the evidence is that the fracturing process sends out very, very minor energy waves and could not cause an earthquake.
Well, let's just say I don't agree with you about that, and there are countries that are on my side and not on your side about that. So one last thing. The only thing that I've concluded so far is that we need beyond December 13th to do this. The number of questions that I have about this are voluminous. They're voluminous. And the whole audience here, I'm going to say 90% of the people sitting out there are going to come after you and tell you why this process, you have not given it enough time and enough thought into what you're doing. And so I say that with respect to my constituent, Mr. Russo, who, are you still my constituent, Steve? I think so. Anyway, and for the work that you do. But in my opinion, you need to expand that process to have a more thoughtful, comprehensive comment period, because everyone on this dais up here probably could take 45 minutes to an hour of your time asking questions just from what you've said, not from what you've written. Thank you very much, Mr. Chair.
Ms. Lupardo.
Sorry. Thank you, Mr. Chair.
I have to be
Commissioner,
teaching a course.
I obviously share a lot of the concerns that have already been expressed by my colleagues, but can we talk about flooding for a few minutes? As you know, my area, the Southern Tier, has experienced 2 devastating 100-year floods in the last 5 years. So I want to talk to you about whether or not, this flooding has caused DEC to rethink any of the aspects of the SGIS. So why don't we just start off with, how do you plan on factoring the increased potential for floods into the permit decisions? I mean, you and I have spoken about this
Yep, and
already.
it's a very good point, and perfectly legitimate question. I don't know of any other state that has prohibited drilling within floodplains. We obviously, once again, took a much more conservative approach, and we are proposing that drilling and all drilling activity be prohibited in a 100-year floodplain. In Pennsylvania, the first question I asked after the floods was there problems in Pennsylvania because they don't prohibit drilling in floodplains? And the answer so far, and again, I'm always, if anybody has information that I don't, I welcome it. We haven't heard of any significant problems related to the flooding in Pennsylvania with drilling activities, or whether it's, damage of equipment or leaks or spills, nothing. It's the first question I ask because obviously, it's easy to look across the border, and they experienced flooding in most of their counties, in many of the counties where drilling is very active. They didn't have any problems. Now, we've proposed a ban in a 100-year floodplain. Should that be increased, decreased? This is, again, what the public comment period is about. If people have better information that will lead us to a different conclusion. But again, even before all these floods occurred, we took the precautious approach and said, it just doesn't make sense to have drilling activities occur in flood-prone areas. So that's where we are. This is also what the public comment period is about. It's to help inform us on this and the variety of topics you've raised.
Well, obviously, the flooding that's occurred has turned upside down the whole mapping system that we have. These maps have not been uniformly revised, as you may be aware, for some time. There's been some dispute over that. Do you think the SGIS should require a site-specific review then for any application involving a location where the floodplain status may very well change as a result of recent events?
We'll consider it. It's a hard thing to answer, I guess, because I'm not sure. Right now, maps have the 100-year floodplain map. In some places, it shows indications where the 500-year floodplain is. I mean, the maps some are in process, some have been revised recently, and others are in the process of being revised. We obviously want the most up-to-date information to use. And we obviously are open to suggestions about how we ought to deal with this again.
In addition to putting in extra precautions, I'm assuming for preventing the flooding of drill sites and waste collection areas, I'm assuming we may have to revisit some of these aspects.
Well, again, what we've done so far, what we've proposed so far is, I consider it fairly precautionary. Most, unfortunately, lots of facilities like tank farms and other things are already located in floodplains, as you know, and they've caused problems in the last flooding. But we, again, what I thought at the time was excess of caution, said none of those activities should occur in a 100-year floodplain. So whether or not it ought to be, expanded or not, or whether there's another way to deal with that in the interim while floodplain maps are being updated, I think is just a good question, and we're going to explore it more. This was obviously a very recent activity.
Very recent. And I just want to back up Assemblywoman Lifton's concern on some of the social aspects. We now have an enormous housing crisis in the southern tier with 5,000 displaced residents, and we've been highly challenged to find places to put them in large measure because of shortages in the Pennsylvania area with housing. So I think that's an important piece to be fleshed out further down the road. And also, we need to just speak on behalf of my constituents who I think are going to be at a decided disadvantage in trying to meet the December 12th deadline. I just need to explain that to you. We can barely even think about the SGIS while we have so many of our residents who are displaced. So that may very well prove to be a challenge for us to meet. I hope you will consider that down the road.
Right.
Thanks.
Thank you.
Mr. Engelbright.
Thank you, Mr. Chairman. How are you, Commissioner?
Pretty well.
Glad to hear it. I have about 4 questions, and I'll try to be brief. The Chairman has touched on some of these, and I think set the tone for many of us up here. I'm concerned about state lands. Let's start there. You've pledged not to allow drilling on state lands, and that's commendable. However, in many cases, the state lands form a mosaic with private lands. And from an ecological perspective, from a landscape perspective, from a visual perspective for tourists, that's a problem if there is a small parcel of private land in the midst of a larger assemblage of public land. Allegheny State Park comes to mind. Usually you see Allegheny State Park as a big green area. In fact, when you look at its actual ownership, there are a lot of private parcels inside, which, if allowed to be sites for drilling, would create a mosaic not of public land as much as of infrastructure. I'm concerned about that. Have you looked at what the implications are? And it's not just Allegheny Park, it's all across the southern tier where the mosaic of state lands and public land and private lands are like a checkerboard. What are the implications for your issuance of permits with respect to this mosaic?
With regard to the location of specific or proposed well pads, it's obviously going to be an important consideration. It may, in fact, trigger a site-specific review if it's within a certain distance from state historic sites, for example. So we would take a closer look at proposed locations that are near or adjacent to critical public lands, historic sites, and the like. And as you've already acknowledged, we took a rather large leap to say that we are going to prohibit drilling on state lands, state parks, reforestation area, wildlife management areas, because again, I think it is fundamentally incompatible with the public's use of that property, and that's why many of these places were acquired in the first place. So I think the short answer, Assemblyman, is that it is going to be a factor in our consideration when we look at individual permit applications, is where are these and what impact will they have on public resources.
But at the end of the day, you will issue permits that will be inside of halos of state land. You go into a state wildlife management area in the southern tier, and suddenly, gosh, where'd that come from? Oh, you mean there was a piece of private land here?
Maybe there's some conservation groups that you can encourage to buy some of those in-holdings. I only say that because I came out of the conservation community, and those would be perfect targets, not just because of the prospect for drilling, but in-holdings are a high priority, I think, for the state of New York and for lots of conservation groups. I didn't mean to be glib about it.
I don't think you're being glib. I think there really does need to be some attention focused on acquisition of those in-holdings inside of our state park lands. There are in-holdings. In some cases, they're just mineral right in-holdings. The state owns the land except for the mineral rights in some cases. So I don't believe you're being glib, Commissioner. I think
some of the audience thought I might be, but I wasn't intending to be.
I think that the state also has to help lead the way toward that. And your agency and the Department of Parks, but particularly your agency, really needs to take the lead on that very important issue. I just want to ask about the compulsory integration process, because it has an impact here regarding subsurface access. Could you define the compulsory integration process?
The compulsory integration process has obviously been around in New York for quite some time, and in order for a driller to submit a permit application, they need to secure the rights to 60% of the land that they intend to drill under. And it requires, the compulsory integration law would require people who don't necessarily willingly participate in that to become, while they may not allow drilling on their land, they are entitled to any minerals or gas rights, or gas that is extracted underneath their property. So it is, it's a way to rationalize and promote efficient drilling in New York, and as opposed to places like Pennsylvania, which don't have, well, actually, it's the spacing laws that are different in Pennsylvania, but it's a way to make sure that gas can be accessed as a resource. And again, the driller in this case would have to get 60% of the people within a unit to agree and sign leases.
Thank you for helping define that. I'm concerned when you say that the state is not going to allow drilling on state land in this hypothetical circumstance, which isn't so hypothetical when you look at places like Allegheny Park, which is more than 60,000 acres in size. There are inholdings that will be drawing and if a well is erected, they will be drawing gas from underneath the state lands. So while you may not allow...
It's true, right.
You may not allow the rig to be, or the drill pad to be located on state land, it will have an impact on state-owned resources.
And the state would benefit from any gas that was produced on that under the compulsory integration law, and we would benefit from that financially.
Within that context, and that the state needs revenue these days, how are you going to be able to assure us that the state would not be leaning toward giving a permit when in fact, in some circumstances, such as inside of a 68,000 acre state park, maybe there should be no rigs taking gas out of that park?
State parks has a permit.
I think you were probably a sponsor in the bill that the governor just signed with regard to Allegheny State Park, where the state parks has a very active role now in regulating any potential gas drilling within the park.
That's useful, and we're grateful for that. The principle does apply, however, all across the southern tier. The mosaic of state lands and public lands in the checkerboard pattern that I indicated will inevitably mean that there will be a lot of gas taken out from underneath state-owned land. I promised the chairman I would be reasonably brief, so let me move on. Assemblyman O'Donnell suggested before that we should perhaps bond. I'd like to pursue that line of thought just a little bit. First, let me just say I think it's commendable that you have required testing within reasonable setbacks from a well to establish a baseline for water quality and water data. Again, that is very commendable. Because without that baseline, when the Demick, Pennsylvania type incidents occur, regulation really is extremely difficult, and it would make the job of your agency that much more difficult, as well as placing a terrible burden on homeowners and property owners who have been affected. Shouldn't there be an indemnity fund created using a bonding, if you will, using industry bonding to set up an investigative capability for contamination occurrences instead of placing this expensive proof on New York State homeowners and property owners?
Assemblyman, I think it is important. And, the comptroller has proposed a bill with many financial assurances. They actually propose a oil spill type fund. I think there is other approaches like just bonding that should be explored also. I think there's several different ways to attack this, but I think financial assurances to make sure that the resources will be available if problems occur is a good idea.
Thank you. The public water that's used by the industry when it does drilling, in New York at least, is owned by the people of the state. And yet this industry will inevitably, if a lot of permits are granted, contaminate millions of gallons of public water in order to carry out their activities. What is the possibility that the state can seek substantial market-based cost reimbursement or compensation for replacement of what will become a damaged resource? Because the water, once used, is chemically altered such that it is substantially less reliable or useful for potable or other public purposes. And it can't re-enter the water system with its original chemistry.
It's an interesting idea. We just took a great leap forward in New York by passing thanks to the Assembly, a water withdrawal bill. We did not have a state water withdrawal bill, so we really had no mechanism in a lot of places to control water withdrawals. We have proposed very strict standards, if you will, that require a significant analysis before the water is withdrawn to make sure that it doesn't impact the supply source, whether it's a stream, lake, or underground water supply. So we have, I think, very good controls to make sure that the actual withdrawal of a significant amount of water won't impact the natural resource. Obviously, a fee or some other mechanism or compensation would have to be applied to all water users. There's golf courses, utilities, lots of industries out there that use large amounts of water already, and I'm not sure that the gas industry should be singled out for that, but it's an interesting idea.
Thank you. And my final question, the chairman touched on this as others have here. I think Assemblywoman Lifton touched on this as well. The economic impact. The two largest industries upstate are farming and tourism. And for this industry to come in such an aggressive way as is anticipated is to place at risk the economic firmament that holds together, as weak as it may be in the economic times that we're in. Those two industries are multi-billion-dollar industries, and they hold together the fabric of the economic vitality of our state. You have repeatedly emphasized that previous drilling in New York, at least, is owned by the people of the state. And yet this industry will inevitably, if a lot of permits are granted, contaminate millions of gallons of public water in order to carry out their activities. What is the possibility that the state can seek substantial market-based cost reimbursement or compensation for replacement of what will become a damaged resource? Because the water, once used, is chemically altered such that it is substantially less reliable or useful for potable or other public purposes. And it can't re-enter the water system with its original chemistry.
It's an Interesting idea. You know, we just took a great leap forward in New York by passing thanks to the Assembly, a water withdrawal bill. We did not have a statewide water withdrawal bill, so we really had no mechanism in a lot of places to control water withdrawals. We have proposed very strict standards, if you will, that require a significant analysis before the water is withdrawn to make sure that it doesn't impact the supply source, whether it's a stream, lake, or underground water supply. So we have, I think, very good controls to make sure that the actual withdrawal of a significant amount of water won't impact the natural resource. Obviously, a fee or some other mechanism of compensation would have to be applied to all water users. You know, there's golf courses, utilities, lots of industries out there that use large amounts of water already, and I'm not sure that the gas industry should be singled out for that, but it's an interesting idea.
Thank you. And my final question, the chairman touched on this as others have here. The economic, I think Assemblywoman Lifton touched on this as well. The economic impact, you know, the two largest industries upstate are farming and tourism. And for this industry to come in such an aggressive way as is anticipated is to place at risk the economic firmament that holds together, as weak as it may be in the economic times that we're in. Those two industries are multi-billion-dollar industries, and they hold together the fabric of the economic vitality of our state. You have repeatedly emphasized a preventative approach. I would just like to suggest that the preventive approach should also be to prevent damage to those existing industries, the jobs that they create, and the myriad of traditions that help define us as a cultural mecca. This is a great state because of its activities in these two areas, tourism and farming. And it just seems to me that it's important that in this environmental impact process that we take a harder look. I'm disquieted when I hear the chairman ask a question about the DOT figures that predict 1.5 million truck trips, and that the DGIS indicates only 5 million. That's off by 300%, each of those figures. And yet, if you're a tourist and you come into a community and you drive down a road and you meet 3 times as many big trucks that are extra wide that are carrying generators and pumps, you're not going to come back and you're not going to recommend it to your neighbors that you go and visit the Apple Festival or the Wine Festival. And it seems to me that a 300% disparity of something as important as truck traffic is got to be dealt with.
Assemblyman, we'll get to the bottom of the disparity. I'm not familiar with where the original number came from, but we'll get to the bottom of that quickly. And as I said before, there are many farmers that have signed leases because they are looking for ways to supplement their income. Ag and Markets is involved in the process. A site-specific environmental review would have to take place for pads that are more than 2.5 acres inside, which the ones that are anticipated from hydraulic fracturing would be. So you'd have a site-specific review. There is a whole host of best management practices like stockpiling topsoil, not drilling or not disturbing the earth below a certain level, not mixing layers of the soil so that it's spoiled when it's returned upon reclamation. There's lots of practices that could be employed to minimize the impacts on farming, for example. With regard to the truck traffic in tourism-heavy areas, we would have the ability to sequence project applications so that we don't flood an area with lots of drill pads at the same time, so we can minimize truck traffic, minimize noise, the things that would impact the attractiveness of an area from a tourist point of view. So I think those are things that are obviously important to us and would be important in the review process.
Thank you. I just, my final observation, and thank you for your response, Commissioner. My final observation here is that this industry is microscopic next to the economic impact of tourism and farming, and to bring it in such an aggressive way, the only way that this can be done responsibly vis-a-vis what we already have as the economic firmament of our state would be that we make sure that we quantify and make absolute the predictable capability of this being value added rather than job displacing. So thank you, Mr. Chairman.
Mr. Kavanaugh.
Thank you, Mr. Chairman. So I'm going to ask a few questions about particularly the New York City watershed and the infrastructure, and then also just touch upon issues of air quality, which haven't really been covered. Let me just generally say that I share the concerns of all my colleagues. I'm going to focus on New York City issues because they haven't been covered, but you know, I share the concerns about these issues statewide. So the New York City DEP and their consultants previously concluded that a 7-mile buffer around watershed and infrastructure of the New York City watershed was appropriate to protect the 9 million people who rely on that system for water. If I'm correct in interpreting the current document, you're proposing a 4,000-foot setback around the watershed and a 1,000-foot setback from the infrastructure. If my math is correct, that's about, it's less than 11% and 3% respectively of what the city has said is safe for that system. Can you talk about why you have rejected, for the purpose of this document, the city's conclusion about what would make that this activity safe for the New York City watershed?
Clearly, the New York City watershed and the infrastructure that's located out of the watershed are extremely important to us. We've already talked to city officials about the disparity in the two approaches we've taken, and we intend to get back together and reconcile what the actual distance and setback should be. I'd emphasize this is a draft document, this is the public comment period, and we're actively talking to DEP. And in fact, we have a meeting coming up with them to talk about this topic.
Okay, and I know we're going to hear from them shortly, but I mean, their recommendation or request of a 7-mile buffer was done in response to the previous draft, and yet we now have a new draft that is,
needless to say, we have a widely diverging opinion about what the distance should be and what the concern is. We want to hear from them. We want to see what they based their 7-mile distance on, and we're going to try to get together on.
I guess what I'm asking you is, what do you base your 1,000-foot distance on?
I think, again, going back to some of the comments that Deputy Commissioner Leff mentioned before, we don't think that from a seismic activity or vibrations created by drilling that there is a significant potential for creating movement near, like the New York City water tunnel, for example.
Isn't the issue also the potential for actual hydraulic pressure on the tunnels themselves, on the aqueducts? I mean, isn't the city's concern not only the seismic issues, but also the potential for these aqueducts are basically built to keep water in, but not necessarily built to keep groundwater at high pressures from seeping into the system?
There was a consultant's report submitted by the City of New York, as you're probably aware. We obtained a consultant report as well, which criticized and analyze very carefully the assumptions and findings of the city's consultant. We will explain in our responsiveness summary at the end of this process all of the analyses of that type that we considered in 2009 and subsequently and disagreed with. In this case, the assumption about a 7,000-foot fracture that hypothetically could transport fluids was simply contrary to the geologic advice and opinions that we received.
So a 7,000-foot fracture is very different from, you're talking about a 1,000-foot buffer. So even if a 7,000-foot fracture is unrealistic, that doesn't really get me from 7 miles to 1,000 feet.
Well, we had previously had discussions with the City of New York that are reflected in an agreement relating to the tunnels of the city to transport water, and the city had previously always agreed that a much shorter, even shorter than 1,000 foot analysis was all that was necessary. So they have taken an inconsistent position on that.
Okay, I guess we'll hear from them also. Your proposed buffer is not a ban, but a area in which additional analysis would need to be done. So the DEC's position is that you could actually drill within 1,000 feet of the aqueducts or within 4,000 feet of the reservoirs, and that would still be safe.
The 4,000 foot is a ban.
So the 4,000 foot is a ban. The 1,000 foot is
you would have to do a site-specific environmental analysis.
So,
but again, I think the main point here is that the 1,000 feet is, we are going to talk to the city more about that and see whether or not it's appropriate or whether it needs to be increased.
And your study, your current proposal is to measure the distance from the watershed, not from the drill pad, but from the drill pad rather than from the maximum extent of the drilling. Is that correct?
Yes, that's correct.
So if I were drilling 1,001 feet from an aqueduct, I could be drilling underneath an aqueduct? Is that not correct?
No, and with respect to the tunnels, that was a 1,000-foot distance from any portion of the equipment. The horizontal wellbore, 2,000 feet below the tunnel or the well pad. So in that case, the 1,000 foot would be measured from any potential source.
Okay, because we had testimony at a city council hearing that was not the case from various sources. So I think that might be something we need to clarify. I just want to briefly touch with the chairman's indulgence, just briefly on air quality, because we haven't really talked much about that today. The effects of this activity on air quality stem from methane and other gases that might be released during the drilling itself, from exhaust and from truck traffic and other traffic at the sites, presumably from toxic fluids that might evaporate into the air during use or storage or spills. Are there other potential impacts on air quality from this activity other than those? Is that the range?
Gene?
I didn't listen to all the details of that question.
I think you listed the major sources of, potential air contaminants, and the air section, again, in the SGIS is fairly exhaustive about modeling those potential sources and proposing a whole series of controls that we would insist upon to make sure that air quality standards are adhered to.
And so, but you have an assessment of the cumulative impact of this activity on air quality in the state and in localities.
We do, and we would commit to monitoring locally also to make sure that we can verify the actual, again, modeling is only as good as the models that are used. We're pretty confident in the models, but we would monitor at the sites to make sure that air quality standards wouldn't be exceeded.
Would the cumulative impact of air quality be considered in the decision of whether to issue permits in a particular area? The air quality, either existing air quality from other sources or from previously permitted drilling?
Go ahead, Steve.
Assemblyman, if I can answer that, it's important to understand that, again, it's a generic EIS. We're going to look at the cumulative impacts to the best of our ability that we can. When it comes to mobile sources, truck traffic, we don't know where the well pads are going to be. We can't do the kind of precise kind of transportation modeling that you would do where you had, say, you knew a shopping center was going to be someplace or not. We simply can't do that, nor are we required to. But in any application, if it was determined that there were new significant adverse impacts that were not identified in the EIS, then we would be required to do a supplemental environmental review. And so that's how we would handle any issues like that as opposed for specific. So it's very important to understand that we've looked at it generically the best we can, but on any application, every application will be required to see whether there's any new impacts that we didn't consider in our generic analysis. And if we do, we're going to have to.
So, at this stage, I mean, you don't know where the impact's going to be. We don't know exactly where the wells are going to be. We do know that there is going to be presumably an adverse impact on air quality in New York State.
Well, we don't think so. That's not true. Our conclusions. Our conclusions. I'm sorry.
Please don't. Let's just have a conversation.
Our conclusions in the document are that with the mitigation measures that we have suggested, that there will not be any violations of the air quality standards.
I didn't ask if there'd be violations of any applicable law. I'm asking, is it the department's conclusion that there will not be adverse impacts on air quality in the state of New York as a result?
Correct,
of this?
because in New York, the way we determine an adverse air impact is, will it contribute to a violation of an applicable standard?
Okay, so in layperson's terms, will the air in New York State get worse from a health and a more environmental perspective as a result of this activity?
No.
There will be no. Okay. So that's the basis for your conclusion previously, that there'll be no negative health effects. And the best estimate of the health effect of this activity in New York is also that there'll be zero health effect?
Well, because the standards, again, the standards that are applicable are health-based standards. They're very stringent EPA-based, health-based air standards. So yes, that's why those stand in any environmental impact statement for whether there'll be any significant adverse air quality impacts.
It's just, I'll conclude, it's just a remarkable conclusion that you could have millions of truck trips and all this industrial activity will have no effect at all. It's a shocking conclusion. Thank you.
I'll just say there are millions of truck trips dispersed over hundreds, if not thousands, of miles of land. And as I said before, if there was a specific confluence of truck trips that tripped a standard, that could be and should be and would be considered with regard to that one application.
Ms. Jaffe.
Thank you, Mr. Chairman. Commissioner Martens, first I'd like to thank you for visiting Rockland County during the height of the storm and the aftermath, and your presence was very much appreciated. I do have concern, and you actually raised an issue earlier regarding the resources in terms of staff that would be needed to be able to respond to the permits. But given how DEC staff has already been decimated, and over a period of time, there would certainly need to be oversight and monitoring on a regular basis to assure that the environmental issues are responded to and the community is protected. How are we assured, and how can we feel comfortable that there would be the kind of staff available to be able to provide that oversight?
We've been working very closely with a panel that I put together when we released the draft document in July that is looking at the resource issue. And the department has already come up with estimates of the staff that would be needed based on activity that we currently undertake and how much time it takes to review permit applications, how many site visits we need to make during the kind of the critical stages of drilling, and we extrapolated based on the number of applications we expect to receive. And we've estimated, and I stress that it's an estimate at this point still, and we've shared this information with not only the advisory panel, but we've had assembly staff members that come to the meetings, that about 140 new staff positions would be needed at DEC, mostly in the minerals division, but in air, water, solid waste. So in various divisions, we would need 140 new positions to staff up for the initial expected number of applications. We expect to come up with a slew of recommendations on how we would raise the money from the industry in order to pay for those positions. We haven't completed that process yet. We hope to have some recommendations in early November. But you're absolutely and 100% right that we would need substantial new resources to properly regulate this industry.
And that's of great concern, because without the oversight and the regulation, we have the danger of enormous environmental impact, and it is of really great concern, and I hope that as you move forward, that's seriously considered in the determination of providing the opportunity for this to move forward. Also, the other question regarding the wells and the testing of the wells, do you have certain parameters in place and structure in place in terms of where those wells, how those wells are tested, where they are tested in terms of the site of the well? Is there a particular company that will be doing the testing? Is it an ongoing testing every 6 months, or is it just the baseline? You can have a baseline and then a year later discover that there was contamination, and then that's after already environmentally impacting the home and the community. Sure. So is there every 6 months the testing takes place? Do you have a real structure in place to assure that the well testing will be provided in a manner that is safe and on a regular basis?
The proposed requirement in our SGS is to have the applicant or the driller test water wells, actual water wells, within 1,000 feet of their proposed well pad to again establish that baseline. And if there isn't a well within 1,000 feet, then to move out to 2,000 feet around a proposed well pad. So it would be each and every well within that radius around the well pad that would be tested. The follow-up tests would only be undertaken, and I can be corrected if I'm wrong, but if there is a complaint from the landowner, if they detect any odors, problems, taste issues.
I believe we did specify periodic testing again after drilling began, 1 or 2. I don't recall how many additional sampling dates would be required.
This is why I have staff here. I can remember every detail.
There would be an obligation on the part of the drilling operator to pay for the sampling and get the results from a certified laboratory.
The next question.
The local health departments, whether they're county health departments or the districts from the state health department, would review that information.
I would hope that you would put within the context of the law the time frame in terms of the regular testing, because just to suggest periodic testing, I would like to see something much more regular than that, and within the context of the regulation.
We'll be happy to review that. Yep.
That would be very helpful. As my colleagues have indicated, we have great concern about this process and about the impact on the community for short-term jobs that will not be long-term in terms of responding to the community. Whether those jobs are from within the community or from outside the community is another issue that has been raised in terms of the benefits. And certainly the impact on agriculture and the tourism is a very real concern. So thank you for your patience, and we hope that you will really consider the issues that have been raised today.
Thank you. We will.
Ms. Corwin.
Thank you very much. Thank you, Commissioner, for being here. Just 2 quick questions, really kind of specific to my part of the state, which is over in the Buffalo-Rochester area. The document presented talks specifically about horizontal drilling in Marcellus and Utica shale formations. My district, we have 32 vertically drilled wells in the Medina Formation, which is just north of Marcellus. First and foremost, the regulations that are being proposed here, would they be implemented in the same fashion in the other formations outside of Marcellus and Utica? Or would there be material changes to that if there was a horizontal drilling permit request in these other formations?
The regulations are designed to cover any horizontal high-volume fracturing, whatever formation it may be done in.
Okay. And just a second quick question, as far as existing vertical wells, would these regulations have any kind of material change on wells that have already been permitted? I mean, is there some way, are these grandfathered in, so to speak, or would you, or we would have the ability to go back and make changes in those wells that have already been permitted? Vertical wells.
Yeah, it doesn't cover vertical wells.
So it won't
they are
impact
covered by
it
the,
whatsoever?
the current 92 SGIS.
Okay. All right, that's it. Thank you very much.
Ms. Schimmel.
Thank you, Mr. Chair, and thank you, gentlemen, for sharing your information with us this morning. It's very, very important what you're doing, and I'm glad to see so many of my colleagues have joined us this morning. I have two questions. I just want to make a statement, a brief statement. In my past life, I worked as a healthcare practitioner in a very large tertiary hospital, and I dealt with life and death situations, and I want to just say that the day-to-day activities, training, experience, formularies in place definitely affect outcome. But you really judge a tertiary care facility, and a company for that matter, by how it deals with emergencies. And one of the things that I'm concerned about, and in looking at the GEIS statement, what about the experience of the companies doing the work? I'm not just talking about the parent companies, I'm talking about the subcontracting. You know, there's a whole new cottage industry, if you will, of people coming forth. And I thought, and I don't mean to be negative about this, but like the gold rush, there were prospectors running to San Francisco to make money. And again, that was a small case. This is big business, but again, not big business. You have an opportunity for a lot of new companies to come up, and venture capitalists and investments, and I know how things happen, but I think about the CVs of these companies and what type of background checks to ensure in terms of previous look-back outcomes of these companies, in terms of their experience, and I underline the term experience, their negligence, in terms of past practice, and most important, their fiscal solvency for the long term. In other words, we're looking at, well, once you decommission a well pad, how do you go back to a company that is no longer there? So I want you to, if you can, speak to that. And I just want to bring up one point, and what brought this to my attention was thinking, and sometimes I used to argue with it in terms of opportunities that the state provides. When a state does a big ticket capital project, they put out a bid process that you have to show that you have a certain number of past experience in training, in terms of doing the work, before you can even enter into a bid for the state. Is that going to be the same opportunity and the same oversight with new companies coming in to do work on this type of process?
Well, you've raised a host of important issues. One is that in terms of the driller's background, we do have a policy at the agency about record of compliance. We do look at a applicant's compliance record in the past, and if they have had compliance problem, that could be grounds to either deny a permit or impose different requirements on them. So that is an important factor, and that applies not just to the drilling industry, but others that come and apply for permits to the agency. We did, in our proposed regulations, increase the amount of bonding that would be required for reclamation, so that, and that's the kind of the narrow regulatory hook we have right now. And but we would, I think we went from $2 million per applicant or of a company to $2 million per well. So obviously significant more financial security that they actually come and reclaim the property and close the well properly. And then you obviously touched on the whole financial assurances issue, which is an important one, which has been raised several times, whether or not, again, an approach like the comptroller recommended, like an oil spill type fund, or just much higher and more stringent bonding requirements are applicable to make sure that there is that the financial resources are available should problems occur. And the other point I'd make is that in 2009, the legislature did increase the penalties for violations of the minerals law substantially. I think it's up to $29,000 a day, if memory serves me correctly, for individual violations. So there's a lot of disincentive, obviously, to violate the terms of their permits.
Thank you. I just want to add, being from Nassau County, and I see certain people from the DC that I deal with in terms of, I'm a constant dialogue with my good friend Peter Scully in terms of oversight. You know, we have well issues and plume issues that predate, I think, even before I was born, and going after these companies. Some of them have been good actors. They're still around. I won't mention their names. They're good actors, and they're stepping up to the plate even 40 years later. But you got to find them, and that's something, you know, we're talking about impacts for the short term, and then the unintended consequences for the next Assemblywoman 40 years down the line. And I'm actually carrying the water, if you will, for people that had done work back in World War II. So we have to keep that in mind in terms of accountability long into the future on issues like this. We don't know. But thank you. I have one more question. Thank you. I have one more question, and I see some of my colleagues here are local government people. We're all from local. We come from the roots of local government, and I do have concerns because I'm from a town and very concerned about certain things, and I feel for local governments, and it's been brought up. One of the things that we talk about in terms of cost to municipalities, how do they prepare for these local plants to process this fracking wastewater, and how that's going to come about. One of the things that's a little bit troubling is there was a quote that even with all the criteria and conditions identified in the revised draft SGEIS, a risk remains that the significant high-volume hydraulic fracturing activities in these areas could result in a degradation of drinking water from accidents, surface spills, etc. And how will that impact the local, I'm not even talking, I mean, I feel for everyone here, every person, but I'm worried about local governments. How will they remedy that when you yourself had mentioned that everything is a risk, but some things are more risky than others? How do we talk to the local municipalities about your own quote that says that there is significant risk?
Well, I've also said many times that we've sought to minimize or eliminate that risk in every opportunity, in every way we can. I won't restate all of the things that we have done to make sure that problems don't occur, but we have built in containment measures, secondary containment measures. It's redundant. It's kind of like an airplane. All the important parts, there's two of them. So if one fails, there's another one there as by way of backup. And that is the approach we've taken in the SGIS. It is the state's primary responsibility to oversee and enforce all these activities. We're not going to rely on local governments to respond to this. Now, local governments will have a role, obviously. They have an important role, particularly for emergency response and things like that. But the first line of defense here is the state of New York, and we are going to aggressively oversee, aggressively monitor, and aggressively enforce. So we hope to, again, to minimize the impacts not only on the environment, but to local governments as well.
I will say, though, and this is not to, you're new to this game. I'm still new to this game. I have seen of late, as the state, because of its limited resources, more and more push down to the local municipality. Without a doubt, if that's the hallmark of my 4 years here, it has been the push down in education, in healthcare, in every aspect, and argue with me but it has been pushed down to the locals.
The other thing I would say is that several of the counties in the southern tier have been very proactive, particularly at the county level, to anticipate the potential drilling activities. They are already involved in training activities and planning at the local level, and I commend them for that. There are county executives and others that have been very proactive about the anticipation for this activity to start, and again, at every level, whether it's emergency services, health services, which is, again, a great credit to the local government's foresight.
Thank you.
Mr. Latimer.
Thank you. Just one question. You've been gracious to sit through a lot of other questions. Very simple question. The deposit of natural gas that's been identified has been there for arguably thousands of years. It will be there if we don't drill it for years to come. Why is there such an intense urgency to do this now when we could measure twice and cut once? We just had an experience, I know it's not completely analogous, of a person who was on death row in Georgia, for which there were doubts raised about his innocence. And I could not understand why the government did not withhold an execution, which I wouldn't favor anyway, but withhold it, providing the fact that you have this person in your control, and you could find out if he was innocent or guilty over a long period of time. But there was an insistence to execute him. So I've listened to questions by many of my colleagues, questions from people in the community, scientific questions that have raised issues that can't be fully answered at this stage of the game, and I don't understand why from a state perspective. I do understand why from an energy company standpoint, when somebody yelled out money. Yeah, there's profit to be made, a lot of it, by those companies that are going to get involved in that. But that shouldn't be our public policy. Our public policy should be absolutely sure. I'll complete just the question. It's obvious what the question is. But given the fact that this is not a perishable commodity, we're not running against a deadline where the gas is going to disappear underground, help me understand why the effort is being made so quickly to close this process off, and I assume head toward permitting early next year.
I would say that we haven't done this quickly. We started this investigation in 2008, long before I started at the agency. Over 3 years, the department has been intensively looking at, I would argue, every facet of the industry, how the process works, how it needs to be done properly. We've looked at the problems in other states, and we've done our very best to address each and every one of those problems to prevent problems from occurring. You know, I think part of the answer lies in the fact that, you know, many of us in New York, including myself, rely on natural gas to heat our homes, to power plants. I know for many years, the state of New York encouraged the conversion of plants from things like coal to natural gas because it contributes less to greenhouse gases. It is a much cleaner burning fuel. So, and we also know as a nation the importance of energy independence. Most of our energy supplies still come from overseas. I'm not sure it's okay to say it's okay to drill in Pennsylvania, Texas, and other places when we have a natural resource here in New York that can be exploited safely. And again, we didn't come to this lightly. We've spent a lot of time exploring the issues and recommending the mitigation measures that we think are necessary to make sure that it's done right. So I don't think sticking your head in the sand on this issue is the right approach. I think we have a responsibility, and I'm not suggesting you're doing that or anybody else. I'm just saying I think if, as energy users, we have a responsibility to responsibly use those energy resources that are at our disposal.
If I may just say in closing, I appreciate your retraction quickly. I don't believe I or anyone else is sticking my head in the sand.
Didn't mean to upset
But all I would say is my understanding is we don't know the chemicals that are being used in the hydrofracking process. We have not yet tested out the levels of maintenance and monitoring that have been identified. We have not seen a state budget that identifies the amount of staff people that will have to be added to provide the kind of oversight that you suggest. All I'm saying, and I appreciate we have a difference of opinion, is that if this natural resource is urgent, but will be there a year or 2 or 3 from now, then it's not a question of urgency today or tomorrow to do it, and we should take every possible minute of time before we just go ahead and do this. But I understand we disagree, and I appreciate you.
I appreciate your point. Thank you.
Mr. Abenanti.
Thank you, Mr. Chairman. Thank you, Commissioner, for joining us today. Most of the major issues have been addressed by my colleagues, and I share their concerns, particularly the concerns of Mr. Latimer, who just spoke. I think he put his finger on this, and I think many of us feel that this is being rushed and that there's a lot more out there. Just because some other states have made a mistake Does it mean that New York should follow that mistake? There are some small issues. Having been in local government with many of my colleagues, sometimes it's the little things that create the biggest problems for local governments. And I mean, one of the things that you discussed, let me just talk about the tax issue for a second, and revenues for local governments, et cetera. What happens when the ad valorem on the tax runs out? Have we looked to see the economic impact on the community? I mean, what's a piece of land that's had all of the natural resources removed, has been hydrofracked? How does that compare in value, taxable value, to what it was before the process began, maybe 10 years before? Have we looked to see what economic impact all of these vacant wells or removed wells or reclaimed land or whatever it is going to be worth, and whether there's going to be a tax base left for these communities at the end of the process? I mean, I'm hearing all kinds of concerns here about land that may be unlivable, houses that are not saleable, with some concern about mortgages. Have we looked at that to see what's going to happen down the line 10, 15 years from now?
I mean, I think the requirement is that after the well has been drilled and production is complete, that the site be reclaimed. It will look like it did before the drilling occurred. The ad valorem tax just applies if the gas is extracted from the property. So there's a benefit only if the gas is extracted. If the assessment on the property, again, I don't see it as being terribly different from when you started the process and when you ended the process. There is an incremental value to the landowner and the local government if they drill, but the land has to be reclaimed, and it would be reclaimed to its original condition before the drilling occurred.
Do you have a process in mind? I mean, do you have people on staff who are familiar with doing this, and a process that's set up to be able to say, well, these are the pictures that we took before of every piece of land, and this is what it looked like before, and this is the way it was set up, and this is the way it's going to look when it comes back? Or
and we've been doing that in New York for 30 years. We've been drilling wells in New York, and reclamations have occurred. I mean, I think there is living examples out there in the New York landscape of reclaimed drill sites, and I think you would, if you saw them, you would acknowledge that the drill sites before and after look remarkably similar. And by the way, that's what the bonding requirement is for. We would require a bond to make sure that if the driller doesn't complete the process, that we have access resources to complete it for them.
A small piece of that is, I've heard that homeowners are unable to get insurance on their homes once they sign one of these leases. Do we have any discussion of that, or any way of addressing that? Or, like the insurance industry is just not willing to continue to insure a home on one of these, or insure the property. Have we seen that anywhere? And
I haven't heard the insurance issue. We discussed earlier the problem with the secondary mortgage market,
right,
and we'll look into that. And we'll certainly look into whether or not there's been insurance issues or problems. But I'm not aware of them.
And also, have you looked at possibly setting up minimum requirements for leases so that the people who have been taken in by the salesman on behalf of the companies maybe have some protection under the law, some minimum requirements? I haven't looked at these leases, but I'm hearing there are reports that people want to back out of them, and they can't, and so it's like a consumer protection issue. I realize you're DEC, not consumer protection, but you're the ones who are doing the licensing. Is there any discussion of some minimum requirements in these contracts to protect the landowners?
It's not something we have looked at specifically. I know that several landowner organizations have combined resources to come up with model lease requirements that are, I know they've publicized. There's lots of attorneys who are now, representing landowners for lease negotiations. So there is a body of knowledge out there about model lease arrangements.
But shouldn't that be part of the economic and social aspect of the environmental impact statement?
Well, it's, again, our focus is on environmental protection. This is kind of a consumer protection issue. And again, I think there are significant resources out there that are generally available to landowners. Because you're right, there has been a host of problems in the past. And again, landowners groups have banded together to come up with model lease arrangements.
I'd like to respectfully suggest that you take a look at that in your licensing process, because otherwise, after the fact, it's too late for these landowners.
Most of the times, by the time they get to us, the leases are already in place. I mean, they come to us after the leases are already arranged.
Well, that's true, but some of them have to get renewed, and they have to get applied in certain ways. And one of the things that we did in Westchester County was to regulate a garbage industry, a trash industry, and it took a long time to get that in place. It was following what New York City did with its trash industry, and whenever there's a change in consumer regulations, it takes a while for it to have an impact. But we haven't done any of this drilling yet. So we could, in fact, make sure, as a condition of the licensing, that the people who own the land are being treated fairly and are protected. That's where I'm going with that, so I would like to see some attention paid to that. The other issue, again, is a niche industry. It's kind of small. I just want to support something that Assemblywoman Lepardo was talking about, and that's the flooding. I'm in Westchester County, where hopefully we're not going to have any of this drilling, but we've had tons of flooding. And your agency is involved, and there are places that are flooding now in the, quote, 100-year storm that never flooded before in a 100-year storm. Mm-hmm. And places where there's been, I mean, we have one place where you have the Sawmill River, and somebody put in a drainage containment area to protect some factories from getting, well, guess what? That lake and the river both overflowed, and now we have this huge area which is underwater when we have this. So I'm concerned here when you talk about 100-year floodplains. Is there any discussion of the contour of the land and the potential for the change in those floodplains?
Well, in a permit application, we are going to look at the site, at the specific location where a well pad is proposed to be drilled, and we're going to take lots of things into concern. Slope, proximity to water bodies, there's a whole, slew of things.
But once it's outside of the 100-year floodplain, I would assume you'd say, well, it's okay.
Well, it may be okay as far as that floodplain is concerned, but we still look at the specifics of the site, and we'll look at whether or not there is, excessively prone to flooding. But I would just emphasize again that we have other requirements unrelated specifically to the actual boundary of the 100-year floodplain that are intended to address stormwater. And stormwater in all types of volumes. And again, we have systems and backup systems to make sure that stormwater is not an issue on a site. And again, I would just, I don't mean to be redundant, but okay. Pennsylvania did experience the floods. They did not have significant issues associated with well pads and drilling operations in floodplains. And we've gone the extra step of saying we're not going to have them in the currently mapped 100-year floodplains. Maybe we need to do more, and again, we're open to suggestions on that front.
Just the last point, I know you've addressed this, the transportation of the hazardous materials and the responses, et cetera. I know DEC tries to respond, but I'm afraid this is going to put a significant burden on the first responders. In many cases, it's the volunteer firemen who come out to see what's going on. And now you're dealing with all kinds of different chemicals, all kinds of different hazardous materials. And the first responders are going to have to be trained, are going to have to be educated in how to respond to this. And that's a major cost for local governments. And I don't know how we deal with that to make sure that people are not hurt the first time they come out.
When the panel that Assemblywoman Lepardo and I take up the local issues beginning in November, that'll certainly, I'm sure, be one of the topics that we talk about.
Thank you.
Ms. Lifton to close.
Commissioner, you can surely feel it. Commissioner, you can surely feel it in the room, and I hear it every day in my district. When I go around my district, I have 10, 15 people stop me the minute I walk out my door and walk downtown. People are extremely skeptical, to say the least, about the ability of New York State or any state, in spite of your best efforts, in spite of all the work you've clearly done here. Not enough in my view, but still a good deal of good staff work, I understand. Extremely skeptical that this industry can be adequately regulated, and they are very scared. People are scared without it even seeing it in front of them. And I saw people in Pennsylvania all day long who were really scared, who had lived through it and said, we hope New York doesn't do this. We supported this industry coming into Pennsylvania. To a person, none of them said that they had been against the industry coming in. They had supported it. Many of them had leases. And they said, we wish we hadn't. It's been the ruination of us, of our health, of the value of our property. And so, there's so many issues we haven't even touched on. We haven't even touched on climate change, a critical issue. I disagree with the assessment. It ought to be the 20-year window. The climate scientists are all telling us we must look at the 20-year window. It's running apace. To look at a 100-year window is not accurate. So it is, in fact, dirty. It is not a clean fuel. And we shouldn't be doing it and contributing to climate change. I think... New York shouldn't be another guinea pig. We should say, until Pennsylvania can give us a truly successful model, a prototype that protects public health, that protects our drinking water, we should not allow this industry into New York and say, we're going to try to regulate it. I wasn't going to.
Commissioner, thank you for being here today. Thank you.
Thank you. Thank you, Mr. Commissioner.
I couldn't hear over the applause.
I wasn't going for that. It's really how I feel, and it's really what I hear from people. Thank you.
And I appreciate all of your comments, your questions. I do look forward to, engaging in constant communication over the coming months. So thanks for having the hearing.
Thank you. Knock it off. Knock it off. That's so inappropriate, I can't begin to tell you. Those of you who are going to testify will have your chance to say what you want to say. If you want to put it in writing and send it to this committee, you'll have a chance to do that. Yelling out at people who are testifying is inappropriate. Everyone here is going to be shown the proper respect. Next is Carter Strickland, Commissioner of the New York City Department of Environmental.